my pleasure and honor to introduce to you the next speaker, the last keynote speaker for this conference. I can also say my friend from many years ago. He used to do legal work for an organization that I headed almost 10 years ago. And I promised him that I will continue to bother him in the future and invite him to conferences all over strange places. And so now he's here with us. MK Simcha Rothman is a member of the Knesset in Israel. Not only a member of the Knesset, he's also head of the Committee on Constitution, Law and Justice, which is basically the Knesset, the parliamentary committee responsible for all legal matters that are dealt with in Parliament. And if that is not enough, he's also one of the, I would say, the two main motors of the attempt of having a significant judicial reform in Israel with his colleague MK and now Minister of Justice Yariv Levin. Simcha initiated a very important effort. As you may have heard, it caused a lot of national and international interest with very polarized opinions. But one thing is for sure, when I would say when Simcha entered the public sphere, I would say that the issue of constitutional and legal reform in Israel was an extremely fringe issue. If you could find 5% of the people who knew anything about it or were interested, you were lucky. Maybe in legal circles it was debated sometimes, but it was virtually a non-issue. And thanks to his work and the work of other people, but very much due to his work, the issue of this constitutional reform has become a central issue in Israeli political discussions, and even those who oppose his own proposals or specific proposals are now convinced that some kind of reform is needed, and this at least is one very important achievement. And hopefully, I would say this naturally in this period during the war, everything on both sides has stopped except for the addressing the problems caused by the war. But when hopefully it will be finished, hopefully soon, I believe that the Israeli public and political system will come back to the issue of reforms. And from my point of view, I can only wish Simcha success in that. And please come and address this distinguished public. And Steve.
Thank you very much, Ofir, and I want to thank the hospitality that I got, and the host of the conference, the Danube Institute, and the Center for Fundamental Rights, and the European Conservative for having this event that, for me specifically, I can say gave a lot of hope, because if there is a problem that so many people in so many different countries are facing, with all, I'm a great believer in the wisdom of the many. So many great minds are thinking on the same problem. I know we will have also those minds thinking about the solutions, and I hope we will be so lucky to implement solutions to these problems. I want to start by a quote that I think that once you hear it and you know who said it, you can learn a lot about the justice system in Israel and about the problem of rule of law and constitutionalism in Israel. I have the fortune or the unfortunate luck to be the head of a constitution committee in a country without a constitution. So some would look at it as an opportunity, some would look at it as a challenge, but the state of Israel does not have a constitution. Sorry, we have a constitution, but no one ever wrote it, and no one ever bothered to tell us what it says. And we need to guess it based on the rule of law, or better said, rule of lawyers, that tells us from the court what our constitution tells us. And apparently they are the only ones that can hear it. So I want to start with this quote. Imagine, if you can, a Supreme Court that has gained the power to choose its own members, set aside legislation and executive action when there were disagreements about policy, altered the meaning of enacted law, forbidden government action at certain times, ordered government action at other times, and claimed and exercised the authority to override national defense measures. Imagine a Supreme Court that has created a body of constitutional law despite the absence of an actual constitution. No act of imagination is required. Israel's Supreme Court has done them all. This was written in 2007 by Judge Burke from the US when he tried to understand what happened when he read the book. It was a book review that about a judge in a democratic society by Aaron Barak, our Chief Justice for many years, and Justice before, then a Chief Legal Advisor before. And when Barak wrote his book, A Judge in a Democratic Society, I think Israel was a democratic society. You heard Gadi before. It's very hard to talk about a democratic society, especially in the rule of law. Of course, Israel is democratic, but not because of its laws, and not because of its courts, and not because of the rulings of the court. Israel is democratic because the people of Israel are democratic by nature. The people of Israel, even before they had a state, had a democratically elected representational bodies. I believe we stand here in Budapest, right? So in Budapest, the Jewish community for centuries had their own elected representation as a community. And Budapest was not unique. Almost every major Jewish community around the world has a representational elected body. So we are democratic in nature. Some even would say almost too much. Our first prime minister, when he met the president of the United States, and he told him, I have a lot of work to do. He says, just imagine what I have in the US. I have so many more people, so much more land. He says, yes, but you are a president of then 200 million people. I'm a prime minister of more than 1 million prime ministers. So in Israel, we are very democratic. Again, as I said, maybe too much for that matter, but not because of our laws and not because of our courts. And it's exactly the other way around. Meaning, Judge Burke said in this quote about judges electing themselves. Too bad I don't know any other democratic country where sitting Supreme Court justices has a veto power who will join the Supreme Court. That's the reality in Israel. So when people criticized, and you can always criticize, again, we're a democratic society. It's okay to criticize my ideas of how to change mine Justice Minister Levin's idea, how to change the way we elect our judges. And they had some points there, some points that. But you need to understand the baseline. The baseline is in Israel, like no other country. The judges elect themselves. And believe it or not, the fact that they only have a veto power and not the deciding power, that's an upgrade from what used to be. Because before that, you had Israel Committee of selecting judges, which I was a member of before and when I was in the opposition. Israeli committee is committee of 9. Committee of 9 with 3 Supreme Court justices, 2 members of the bar. Now, I bet there have some lawyers here. As a lawyer, I went to learn law because I don't know math. If I was good in math, I'd probably go to high tech. But Israel, startup nation. But I went to learn law. But I don't even need to tell you who are the other 4, because if you said 9, and I already mentioned 5, that's the majority. So, but the majority, you have 2 ministers and 2 Knesset members, usually one of the opposition. But what does it mean? It means that the entire population of the state of Israel, coalition and opposition together, are represented by a minority in the committees that select our judges. So even if all elected officials, again, coalition and opposition, say this judge is a bad judge, don't appoint him, he is appointed to be a judge. Because bar, as you know, works a lot with the court. The lawyers and are staying there. The elected officials are changing constantly. So they will cooperate against the elected officials. So there was an amendment made by a shared friend of me and Ofir. He offered it as a Knesset members around the time this was written, 2007, 2008, and then we removed the power for them to appoint a Supreme Court justice all by themselves, and now you need 7 out of 9 in the committee, meaning they had a veto. We didn't take their power to prevent, but we did take their power to enforce an appointment in the Supreme Court. Again, it's an upgrade, but the system is flawed. You can upgrade and upgrade and upgrade and upgrade, but nothing will turn a bad car into McLaren racing car, even if you will upgrade it over and over and over again. So I did not say affirm because I don't know what most people here drive, and I don't want to offend anyone. So this is electing judges. Okay, but once they are elected, are they operating like judges in the real world? The answer is no. Because Israel does not have, again, it's not in, you cannot find it anywhere in the way they speak. But Israel does not have a demand for legal standing, meaning anyone can bring any case to the Supreme Court directly, no appeal. So you have one entity that can decide anything just because someone filed an appeal. Now, what I mean anything, I mean anything. Examples. Ukraine had a war. Israel accepted a lot of Ukrainians as refugees. Some of them were Jews, so they came through the law of return in Israel. Some of them were tourists. But they came to Israel running away from Ukraine. But it wasn't enough for some people. And the embassy of Ukraine in Israel hired a lawyer, but he didn't file the appeal in the name of the embassy of Ukraine, which would make some strange sense, but it would. He appealed on behalf of his own, saying Israel is breaking the agreement with Ukraine on tourists and demanding visas. Now, I don't think there is any court in the world that will hear this kind of a case in any of your countries, and we heard a lot. The court took this case and decided it against the government. So I can think about many reasons why an agreement, even if it says what it says, would be changed because of a war. I would say it's a circumstance that might, the sovereignty of the state of Israel, by agreeing to Ukraine tourist visas, if there is a war in Ukraine and a tourist from Ukraine will not return to Ukraine, I would think it's a legitimate consideration in the sovereignty of the state of Israel. Who cares? Who cares about sovereignty? Who cares about legal standing? The decided it against the judgment of the Minister of Internal Affairs at the time, Ayelet Shaked. Okay, that's strange. Rules of conduct by the army went to court. What way will you, not after the matter in a kind of a lawsuit, you break it, you did not break it with someone was injured. No, just to decide it from scratch by the courts. So the question, if someone, let's just talk hypothetical ideas. Let's just imagine people go to the fence in the Gaza border towards Israel. Can we shoot them or not to defend the Israeli border? It's never happened, right? No, it happened. It happened over and over again. We can talk about the decision that the court has taken. Wrong. There is a lot of unwritten decision-making behind the decisions. But I'm not criticizing now the decision that the court has done. The idea that the court has heard this case is unheard of. No court in any other place will do it. Appointments. What is the power of a government if not to appoint high-ranking officials? So as we speak now, the Minister of Homeland Security in Israel sent a letter to the head of the police. And he said, I'm not happy with your work. Come, I want to think if I want to fire you or not. You can say that a country in a wartime where people are blocking roads constantly and the police don't do anything to do it, is it legitimate consideration or not? It's an arguable question, but I don't think anyone in a democratic country will say that the responsibility of the functioning of the police lies within the Homeland Security. And if the minister wants to, and by the way, there is a specific law in the books saying nothing in this law, the rule of police, will prevent the ability of the minister to fire every policeman that he wants to, based on his own discretion. It says it in the words of the law. So we sent him a letter. So the chief legal advisor said, you cannot do it. Why you cannot do it? Because you did not offer enough background. No, he didn't even went to court because the chief legal advisor took this power to block any government action, including appointments. But it doesn't stop there. Where did the chief legal advisor take this power? Which law governs the ability of the chief legal advisor to do those things? The answer is no law. The answer is the laws sometimes specifically says the other way. But the court gave the chief legal advisor this power without any law. And when you try to change this law, the court tells you it's unconstitutional based on what constitutions that says nothing. So this is the gridlock or the Gordian knot in Israeli justice system. And so this is, so you would say, okay, it's high-ranking officials, but at least they let you, the ministers themselves can be appointed by the Knesset. In Israel is a parliamentarian system, Westminster, and we vote confidence in the government as a whole with the ministers. So if there is an elected government, at least on that we have the ability to rule ourselves. The minister cannot do a lot because the court will prevent him from anything, but at least the idea of representative democracy we have, right? Even a minister, so there are rulings in Israel saying that even a second after a minister is appointed by the parliament, the prime minister must fire him. And if the prime minister does not do it, it's, wait for the magic word, it's unreasonable. So it's reasonable for the prime minister not to fire a minister that the Knesset has just voted confidence of the prime minister and the minister. And that therefore the prime minister must fire this minister. And the court will hear this case again without any demand for standing. So if I don't like, I don't know why someone in Israel now would be in my position, but let's just imagine I don't like the works of Secretary Blinken in the United States. I don't know why. Let's just imagine. I can go to the American Supreme Court and say that Biden must fire Blinken because it's unreasonable not to do it. And I can have a big body of evidence that it's unreasonable to leave him in office, right? Can I do it? No, I cannot do it. Not because I'm not an American citizen. Even an American citizen cannot do it. Even an American NGO cannot do it because there is such a thing as Constitution, cases and controversies clause. You need to show the controversy. You need to show standing. All this different mechanism that prevent judicial tyranny. In Israel, they just don't exist. No, it used to be. So whenever I tell this, some people think I'm bluffing because it doesn't make any sense and say, why did you create this system if it's so stupid? And it's a reasonable question. Sorry for the term reasonable. It's been misused so much in the past year and a half. But it's a reasonable question. And the answer is that we had a court that no one cared that they appointed themselves because they did not have this power. So when courts in Israel were formed, they did not have the power to cancel laws. They did not have the power to cancel executive decision based on vague terms, only by legality, if it's legal or illegal. They did not have the vast oversight power that they took to themselves on everything you can imagine. And they restrained themselves not to deal, although theoretically they could have, because there is no law regulating the matter in the common law. They were self-regulating not to work on issues of national security, foreign affairs. They self-regulated. But then they threw all those limits. So if you have a court that it is really the weakest branch of government, as Hamilton said, but I'm not sure he was right about the US, but in Israel, yes, he might be right, because it wasn't a strong branch of government for many, many years. It was respected, but he did not misuse its powers. So no one cared that they appointed themselves, because they did a quite good job. But over time, they took more and more power, and Barak, which his book is the base of the criticism of Judge Burke, he was the architect of this power grab by the courts over the years. So once you put all pieces in place, you understand we have a self-appointed judiciary who can cancel laws, who can, you heard Gadi, decide what the Constitution says and what the Constitution is. And I did not even start of the main problem. The main problem is interpretation. Because rule of law is a nice word. Constitution is a nice word. The words of the law, especially as a legislator, I must believe, are nice, mean something. But if words don't mean anything, and you can say that black is white and white is black just because you want to get to a certain outcome, that's why you go and make the words mean things that they don't, you basically have no limits on your power. And it's not my idea. George Orwell thought about it way, way before me. That freedom is to say that 2 + 2 is 4. Not to say that 2 + 2 is 5. To say that 2 + 2 is 5, that's not freedom. That's the way you take away freedom from people. Freedom is the ability to say that 2 + 2 is 4. And the fact that we are trying to, and Ofir mentioned I am the last keynote speaker in this event, I listened to a lot of people, and the main problem is that the freedom to say 2 + 2 = 4 is going away from us all around the world. And you let people see the statue and ask them, how come you reached from point A to point B? It doesn't work. It doesn't work. And I want to have two examples. One in an issue that I believe everyone here understands because it's a global issue, but it has a unique Israeli taste or flavor: immigration. So in Israel, we have a law saying that you cannot get Israeli citizenship through marriage if you are from certain countries. Palestinian Authority, and Gaza, of course, and other enemy countries. Most countries would not need this kind of legislation. Israel, with the security issues and the neighboring countries, need it. And the reason we need it is because just recently, the police arrested, believe it or not, the sister of Ismail Haniyeh, the head of the Hamas. She lives in Israel with her entire family. No other country in the world. I heard some people here are in exile for their own country because they are a little bit outside. A little bit, of course, I'm not judging from afar, but if you compare it to the differences between Hamas and Israel, the differences between different branches of different ideologies in other countries become smaller. And they cannot stay in their own country because of difference of opinion. I believe that if the difference of opinion was you need to kill and rape everyone else, they wouldn't live there. In Israel, we have the sister of Ismail Haniyeh promoting in its family WhatsApp group terror attacks. She lives in Israel. So if you allow family reunification, just imagine what it would do to our security. But the court does not care, because the court canceled time and again the law that the Knesset did to prevent exactly that. And now you can bring your family members, immediate family, let's do a background check. You can marry a Palestinian and get her to Israel, and their children will get Israeli citizenship. And they will be taught from age 0 to kill all Jews. and they will live within our borders, and Israel is defenseless against it because the court took away the court and the legal advisory operating together. So this is a major problem, and the court shouldn't have been in this issue to begin with. And the amazing thing is that this law was passed by the Knesset with a majority of more than 80 Knesset members. It's not a fringe ideology. The fringe ideology sits in the Supreme Court. Because when I passed a newer version of this law, when I was in opposition, the initiative was mine, and I brought the entire coalition and opposition to vote for it, besides the Arab parties and one Jewish party, small one, who did not pass the threshold in the last election. But the court accepted the views of this fringe party and rejected the views of the vast majority of the public in Israel. So to say we are a democracy, we're a democratic people. Are we a democratic country? Questionable. Questionable. And the last issue, because I heard you speak, and you spoke about the tension between European Union or other international powers and the sovereignty of the state. So the rule of law is sometimes might be used against Hungary, against other countries in Europe, in France, and Spain, and Belgium, or whatever, from an international entity, semi-international European entity, or international altogether. But you have the ability, sometimes, with the benefits, with the damages, to step out of this international interference and opt in, opt out, depends. But that's the issue. Israel is not part of the European Union. I don't want to imagine what they would do to us. But it's not part of the European Union, but we are a part of the world, and we are under a lot of tensions from the world. But what we see with the ICC and the ICJ just recently says that it's not an issue. We saw that it's not an internal issue. The misuse of the rule of law and the misuse of rules by judges and by unelected officials. It's not only Israel, but we see it with the ICJ and the ICC. And as always, the people who do not want to cater to the will of their own public, of their own electoral representation, they use the outside forces as a threat or to enforce on their people. And the fact that the anti-genocide treaty that Israel was promoting in the beginning of the year, is in the beginning of its building, based on the lessons we all learned from the Holocaust and from the World War II, is misused against the only country in the world that does not do genocide in any way when fighting the most horrific terrorist organization we can imagine. I believe there are some peacekeeping missions that had more civilian casualties than Israel war in Gaza. And the fact that they're talking about genocide when numbers show very clearly that we have today, after 75 years of this genocidal tyranny called Israel, we have more Palestinians in Judea and Samaria and in Gaza than any other point in history. And their welfare and life expectancy and food security is better than any other group in the Arab world beside maybe the Emirates. And so to blame us in genocide, if you do it, you can really misuse the term rule of law and constitution and human rights. That's what you do. And it's, again, also with the ICC. But during the judicial reform, constantly I got warnings by people of the legal establishment in Israel saying, listen, we are the only, the last defense, the only and last defense from international forum. And if you change the justice system, you will have international measures taken against you. So basically, they're trying to use the ICJ and the ICC to take care of appointments in the civil service. I did not touch in all the offers that were on the table during the judicial reform. There was nothing connected, even remotely, to war, or to criminal procedure, or to prosecution of war crimes, any other thing that connected even remotely to the defensive shield that supposedly we got from our justice system against the ICC and the ICJ. But despite the fact that, A, we didn't do anything on judges' appointment that we should, we didn't do anything about a legal advisor that we should, we didn't do anything. We only changed the reasonableness clause, which mainly used and never was used on decision-making on war, never, by a minister or by, that's what we changed, but mostly been used on appointments. So we didn't, and even that was canceled by the Supreme Court, again, without any authority, without any legal grounds. And we send Chief Justice Barak to be part of the ICJ. Because he's the defensive shield, right? If he cannot protect us, then no one. And the answer is, and it always was, you cannot depend on your own court system as a defensive shield against the international powers, because the question in the international court has nothing to do with law and has nothing to do with international law. It has everything to do with politics and statesmanship and pressures, and the fact that the Chief Justice in the ICJ was appointed by Lebanon, a country that's shooting rockets at us at the same time, just shows you that it has nothing to do with law or justice or rule of law. And the claim that our justice system, our flawed justice system, not because they are not prosecuting war crimes, not because they are not limiting the state of Israel from acting in a war, but because they do it too much, it's flawed. They do it more than any other country in the world. But it still did not help us a little bit. Not on the ICC front, not on the ICJ front. And the help that we got from our friends, from the US, from Hungary, from other countries, that might help. But limiting the will of the democratic people of Israel from legislating, from amending the basic laws, which is the quote-unquote, the constitution or semi-constitution, or from protecting, in the most dangerous neighborhood in the world, from protecting our people, will not help us in the international front, will not help us to observe rule of law, and will not help us to say the simple truth. Israel does not commit genocide. Israel does not break any international law norms. Israel has a strong and independent justice system. With the reform, even if all the reform would pass to the word, it would stay that way. And the most important thing, 2 + 2 = 4. Thank you very much.
Thank you very much for that, that vivid description of, well, the phrase that stood out to me was the Gordian knot of the Israeli justice system. That's a fabulous phrase, and I tend to think that many justice systems have their own Gordian knots, some of which we're trying to examine and perhaps even show the way in which they might one day be cut. But I would like to welcome the next panel to the floor. We have a distinguished panel with representatives from the UK, from Venezuela, I believe, and from Spain. It will be moderated by Sébastien Meuwissen. I hope the pronunciation is passable. So I would welcome you all to the floor. And Sébastien, I'll leave the further introduction of your panelists to you.
Ladies and gentlemen, let me start by introducing our speakers. I will be talking about the topic entitled When the Rule of Law Breaks Down, in company of Mr. Javier Torrox from Spain. He's an analyst, journalist, and translator, and asked me to introduce him in this short way, so I ask for your applause. We will be discussing also with Mr. Alejandro Peña Esclusa, who is a writer, analyst, and political consultant, a specialist on Latin America, who will talk to us about the backlash on the rule of law under the communist government in Venezuela and his tumultuous adventures when he was, among others, imprisoned. Please clap for Mr. Peña Esclusa. And our third panelist will be Mr. Fred de Fossard, who is Director of Parliamentary Affairs, Head of the British Prosperity Unit at Legatum Institute in London. But if you allow me, let me start with a few words about Poland. I apologize in advance if I will repeat some of the things you have already heard, but I have heard many times that repetition is good. I have heard many times that repetition is good.
What have you heard?
A few weeks ago, the European Commission dropped its Article 7 procedure against Poland. For years, the EU was denying Poland 137 billion euros in funds. The Commission argued that the judicial reforms implemented by the conservative government of the Law and Justice Party did not respect the rule of law. But when the Liberal coalition of Donald Tusk formed a government, the tone suddenly changed. The European Commission turns a blind eye on the blatant violations of the rule of law, which were mentioned before. These include the imprisonment of political opponents. One of them, I just make a little bracket to emphasize the brutality of how it took place. So the former Minister of Justice, Zbigniew Ziobro, who is fighting cancer, was laying in a hospital bed when the security services raided his house and basically made a mess of his place. And just a little survey for the public to, because I'm curious if you can guess how long it took for them to realize, to do this raid, basically. Somebody, a guess?
1 hour.
A little more?
3 days.
24 hours. So 24 full hours of tossing around his personal belongings. They even took away the electronic devices of his family members, the tablets of his children, the laptop of his wife, and so on and so on. That's not all. The country's prosecutors got replaced. The central bank president was put before a special tribunal. But despite all this, as I mentioned, the European Commission seems to believe the democracy is back. I will quote to you the tweet of Mrs. Commission President Ursula von der Leyen after the announcement of this great news of dropping Article 7. So here's the quote. I congratulate Prime Minister Donald Tusk and his government on this important breakthrough. It is the result of their hard work and determined reform efforts. I emphasize the word efforts because, in fact, absolutely nothing has changed in Poland's judicial system. Not one single reform was introduced whatsoever. The Tusk government has questioned the legitimacy of certain judges in the Constitutional Tribunal and of their judgments. This decision was based on rulings from the European Court of Human Rights, even though these rulings aren't considered legally binding in Poland. They proposed a resolution in the Polish parliament. However, it is important to note that resolutions passed by the Sejm, so the Polish parliament, don't always have the force of law and aren't typically subject to constitutional review. In Poland, the status of a judge in the Constitutional Tribunal is defined by law. To do so, the Polish constitution does not require a qualified majority, which gives the ruling party at a given time a lot of room to maneuver. Once elected by the Sejm and sworn in by the president, a judge assumes his role and is expected to act independently, governed solely by the Constitution. After this point, the Sejm doesn't have the authority to question or review the status of a constitutional tribunal judge. This is the exclusive competence of the President of the Republic. As I mentioned, I could go on and on with these examples, but I think you get the overall picture. One more thing I would like to add when it comes to the Polish case is something that the new majority has in common, or which characterizes it, I should say, is that it is composed by hardcore leftist radicals. Not all of them, but there are some of them, and I will give you just a few examples to show you what I'm talking about. Minister of Culture, Bartłomiej Sienkiewicz, former colonel and former Minister of Interior, has created just a few days after taking office a blacklist or a list of suspicious organizations which, what a surprise, have the thing in common to have a conservative or Christian character and identity. So he announced that they will be scrutinized and their financial transactions for the previous years will be under detailed scrutiny from now on. Minister of Equality, yes, we have this now in Poland, Mrs. Kotula said a few days ago that she will go to hell and make a pact with the devil for fulfilling the request from the LGBT lobby. Waiting to see that. Mayor of Warsaw, Rafał Trzaskowski, he's de facto not a member of the parliament, but from the same party as Donald Tusk, recently came up with the genius idea to remove crosses from public places in Warsaw. I guess he's preparing the campaign for being president next year. I could go on, but I think you understand. They have in common to not respect the rule of law and having these strong left tendencies. But now I don't want to take time from my brilliant panelists, so I will invite them to take the floor here in the following structure. First of all, we will start by discussing three questions. Namely, has the rule of law broken down? I hope we will have a straightforward answer to that one. Later, when and how did it happen? And eventually, what are the consequences of this? Once these short presentations are concluded, we will be discussing together about what to do about all of this. Once again, thank you for your attention, and I welcome to the floor Mr. Javier Torrox.
Okay, good afternoon. Thanks, Sébastien, for your kind words and introduction. I would like to start thanking the organizers, the Danube Institute, the Center for Fundamental Rights, and to the European Conservative, as well, and most especially to Mario Fantini for having me here today. My two main concerns are political freedom and its corollary, nation integrity. And taking this into consideration, the panel title, When the Rule of Law Breaks Down, brings me to address these three questions that Sébastien named. Has the rule of law broken down? If so, when and how did that happen? And finally, what are the consequences of that? First question, has the rule of law broken down? I think we will all agree has a quick answer. The answer for Spain and most Western countries is yes, it has. Second question, when and how did that happen? Well, I think it has been happening gradually for decades by means of legislation passed even when in conflict with the rule of law. I will try to focus on the essentials for human affairs: life, self-defense, and property. These three elements constitute the basis of individual freedom and therefore Western civilization. All these three elements come before any human aggregate, any polis, in the old Greek sense of the word, meaning tribe, city, nation, nation-state, etc. That is, they were previous to any human legislation, and therefore, I think the rule of law and subsequent legislation must be in harmony with the three of them. Anyway, mankind is more than just civilization. A fourth element is missing in this picture. If we add transcendence, Judeo-Christian tradition, what do we have? Western culture. I've been kindly asked to expose certain instances of how Spain is breaking the rule of law at the present time. And I will try to do that, exposing how Spain does this, following these four elements. Firstly, regarding life, we have three different legislations at three different levels. Abortion, for those who have not been born yet. Euthanasia, for those who are too old or regarded as useless by the system for health reasons or whatever. And in the middle of both, we have the gender agenda, which is promoting transsexuality among boys and girls and even kids. And now we know that the use of puberty blockers will result in sterilization, the impossibility of engendering and conceiving new life. And that is life-cutting legislation. And just an observation on these three approaches against life. There is no imposition for the time being. All three are accomplished willingly by those who choose to do it. Killing is now in Spain an administrative file which is executed by the government. System does not need to be the Minotaur anymore. Modern state has made their citizens choose to be their own monsters. And a final remark on this matter. Who and why is promoting these legislations everywhere at the same time and successfully? If we move forward to the following point regarding self-defense, Spain has made of it such a sporting regulation. It is a sort of Marquis of Queensberry new rules. If you're a fan of John Ford movies, as I am, you know what I'm talking about. With this, proportion is key. If someone enters your home at 4 a.m. with a chainsaw, you are not allowed to use a shotgun to defend yourself or your family. You have to go and get yourself another chainsaw so that you can fight back your attacker proportionally. It is your life. If your life is threatened in Spain, you have two options. You can either let yourself be killed, or you can kill for your life and then go to jail for it. The right to self-defense, we can conclude, does not exist in Spain. Regarding property, we all know that property does not come out of the blue. Creation of property is the product of effort and labor. But Spanish tax burden is beyond 50% of any individual income. Any Spaniard works nearly 7 months a year for the state and only 5 months for himself. Additionally, Spanish main wealth among working class is housing investment. But any day you can go to office, you can go shopping, you can go to the doctor or whatever, and you go back home and you find there is a squatter family in there. In that case, forget about your house. It will take you years to have it back. And in the meantime, of course, you will have to keep on paying your mortgage, and you will be forced to pay for electricity supply, water, gas supply, etc. Spanish lawmakers have ruled what we can call the right to steal houses. Only conclusion is that property in Spain is de facto outlawed. Moving forward, regarding transcendence, there is a lot to say about it, but let us stick to two essential facts. Judeo-Christian tradition is the basis of Western culture, never mind if you are a believer or not. And second, the very state has now erected itself a substitute religion. Its doctrine is a word of power, which changes in accordance to the interests and passions of the moment. Its dogma, the infallibility of government, and its worship, blind obedience. Instead of salvation after life, this substitute religion offers earthly and immediate rewards, the satisfaction of all earthly appetites during life. That is, the annihilation of transcendence with a state-based religion. To sum up, life, self-defense, property, and the sense of transcendence are the core constituents of individual freedom. When legislation in a new culture, which is dictated from power, strike these core constituents of individual freedom, that is when the rule of law breaks down. And when this happens, it is not only a legal building that collapses. It is Western civilization and culture collapsing. Quoting Messier du Juvenal, we are our own barbarians. But the very point of no return regarding the rule of law breakdown was the coronavirus epidemic in 2020 and the year after that. No matter the reasons alleged then or now, Spain and most Western countries broke the rule of law when they broke their respective constitutions. And this takes us to the third and final question. What are the consequences of breaking the rule of law? We can tackle this from two different perspectives. Firstly, the personal consequences for the individual persons that held the offices that broke the rule of law by breaking their constitutions. And there were no consequences. There were no social case, there were no political case, and there were no criminal case for any individual in the governments or legislative houses that broke their constitutions. Nowhere in any Western country. Some may say on this that the UK Prime Minister Boris Johnson was forced to resign, and indeed he was, but not for breaking the UK Constitution, but for partying while breaking the British Constitution. And I think that is an excellent portrait of this first perspective. The second perspective follows this absence of consequences of breaking the rule of law. And I think that the deep meaning of this breach is that Western constitutions are dead. And if Western constitutions are dead, from this follows that the modern state as a political form is also dead. It is not yet visible, it is true. I think it will in due time. But the same way the Soviet bloc fell long before the Berlin Wall fell, the fall of the wall was the factual materialization of something that had already happened. Similarly, I think modern state has died, although its factual materialization is still to come. And I'm afraid that materialization will happen sooner than we may think. My vision is that we are now in the middle of something that has died and something that has not yet been born. We are, I think, in a similar position when the fall of the Republic of Rome, from which Augustus built the Roman Empire. And that meant the beginning of a political decline that took 1,000 years to recover. Hopefully, it will not take that long this time. Anyway, thanks for your attention.
Before I give the floor to Mr. Alejandro, I just want to make sure that, technically speaking, we are able to put on his PowerPoint presentation, and then we can proceed. Mr. Alejandro, the floor is yours.
Good. Thank you very much, Sébastien, and all the organizers for this invitation. Maybe our colleagues would like to sit somewhere that you can see the slides. Oh, you can see them there. Well, that's very well thought. Good. I didn't know also the time, so I don't take more than 10 minutes. All right, good. My presentation is when the rule of law breaks down and the case of study of Latin America. And you would say here, but we're in Europe. We're so far from Latin America. What does that have to be with us in Europe and the United States? It does have to be, has to do a lot, because Latin America has been transformed into a laboratory, a social laboratory for the international left, where they conduct their experiments there, and once they prove them, that they can apply them, they export those experiments to the United States and to Europe. If I have time, maybe later I will give you some examples of what I want to say. And how come Latin America has become a laboratory? Why? Why it has that characteristic? This is to pass the slides here? Could you show me? The green. The green. Here? Good. This is why. These are the 22 countries belonging to Latin America, and the red ones, Chile, Brazil, all of those, until Mexico, are the ones that are governed by presidents that belong to the Sao Paulo Forum. I don't have time to explain much about the Sao Paulo Forum, but it's the most important leftist organization in Latin America and was created 30-something years ago by Fidel Castro and the actual president of Brazil, Lula da Silva. So the fact of having 10 presidents belonging to the same leftist organization gives them the impunity, they help each other, the impunity to conduct the experiments that I'm referring to. Those 10 countries include the most populated ones of Latin America, that is Mexico up north, Colombia in the middle, and Brazil. Those are the most populated Latin American countries. So you have Andrés Manuel López Obrador in Mexico, Gustavo Petro in Colombia, and Lula da Silva in Brazil. So they have developed a method to do lawfare. I'm going to concentrate more on lawfare. I think someone who preceded me, Sébastien, this morning, Martin, I don't know if he's here, he was talking about other breakdown of the rule of law in Latin America, and that was very well explained by a Venezuelan lawyer by the name of Brewer Carías. He mentioned that today. So that is a part of the destroying the rule of law. I'm going to concentrate more on lawfare. The method of lawfare in Latin America, which is being implemented for more than 20 years ago, is first, international campaign to criminalize leaders, even if they're innocent. And these are communication media, newspapers, social networks in all 5 continents that repeat exactly the same thing about certain right-wing leaders or movements. Then legal procedures to imprison them or to disqualify them. And most importantly, even though it doesn't have to do with the victims itself, is the third part. This punishment is used to dissuade, to introduce fear for the rest of the population. If you try to be like Bolsonaro, if you try to be like Álvaro Uribe in Colombia, you will go to jail, your life will be destroyed. So that's a way to create a totalitarian system, creating panic. So I will put very quickly 3 examples of this criminalization of right-wing leaders. The first one is Jair Bolsonaro, former president of Brazil. He was accused at the International Criminal Court for genocide, for mishandling the COVID pandemic. All he did is that he did not agree with the World Health Organization, that's all. And he said it. And when he said that, he said, we're going to go against this guy, all right? So they accused him of genocide. What was the reason between this? They said, well, in Brazil, there are 39 million cases of COVID. That's too much. This guy is committing genocide. Not death, but contagions, 39 million. What they did not explain is that this happened because Brazil has 220 million inhabitants. Of course there's more contagious because there's more people. And if you measure the quantity of people being sick of COVID in comparison to Argentina, Brazil had 1.8 cases for 10 inhabitants, while Argentina, who was run by a Sao Paulo Forum president, Alberto Fernandez, 2.2 cases, more than Brazil. But the one who was attacked was Bolsonaro for ideological reasons. So they use this sick, let's say, rationality. The other one is my good friend, who is in jail, former president of Bolivia, Janine Áñez. She became president because Evo Morales committed a massive fraud and he escaped from the country, and she was the one in the line of succession and became president of Bolivia. So the left made an international campaign for months and months and months saying that she perpetrated a coup d'etat. Now she's in jail. Even though the final report of the OAS explains very well that technically how this fraud was committed. One of my books, The Electoral Frauds of the Sao Paulo Forum, has a chapter on how this fraud was committed in Bolivia, and also speaks about other frauds in Latin America. Now, this is the third case that I know personally, because this guy is me. And what I have in my hands, in my wrist, is not this watch, they're handcuffs. This is the political police putting me in jail. This is the parliamentarian question in the European Parliament about my case. And they didn't have anything on me, anything. They invented things, so they put me in jail in this place. This is the famous Helicoide, torture center for Latin America. I was not tortured myself, but many people have been tortured there. That's a political prison for political prisons in Venezuela. That's the third case. And the method was the same. During years, they lied about me, creating this situation that when I was put in jail, people would say, well, after all, this guy is this or that. Because the importance is to use the communication system to criminalize their enemies. This is done by the left, all over. And this experiment has been conducted in Latin America all the time, once again, and then exported to the United States and Europe. That's why Donald Trump says, United States has become like a banana republic. Yes, because in the banana republic, they experimented the method to criminalize Donald Trump and others. These guys in Latin America have invested a lot of money, a lot of energy, and a lot of time to develop technicals of lawfare. These books are published. You can find them. They're published for free. You can download the PDF in Brazilian, Portuguese, and Spanish, and the website of the Grupo de Puebla, the Puebla Group. These guys are experts in lawfare, and they've been years developing this. They have sociologists, lawyers, they have philosophers, they have experts in all kinds of different, let's say, knowledges in order to develop very sophisticated methods of lawfare that I will say this again, because Sébastien said that repeating was important. This has been exported to the United States and Europe. Do not be surprised that what happened in Brussels a few weeks ago with an outcome is a result of this kind of methodology here in Europe, in Brussels. Well, I'm going to basically end up presenting to you an international Grupo de Puebla or Sao Paulo Forum. This organization, Progressive International, is the equivalent, the international equivalent of the Sao Paulo Forum in Latin America. It's called the International Progressive, or Progressive International. Who created it? A senator from the United States belonging to the official party of the United States, the Democratic Party. His name is Bernie Sanders. He created this. And this is the equivalent of the Sao Paulo Forum internationally in all 5 continents. Why do we know that? Because well, let me stop here and say this. This is taken. Do I have to be here for the record?
Yes, yes.
I have to be here. Okay.
Would you like a microphone to travel with?
Oh, okay, good, good. Changing microphones. 1, 2, 3. Okay. This posts are taken from the Progressive International official post. What I'm going to say now is a scandal, because this is from a group of parliamentarians belonging to the official party of the United States of America, and they promote Black Panthers, Fidel Castro. You just go to the timeline of Twitter, well, former Twitter, now is X. Black Panthers, Fidel Castro, Karl Marx, Lenin, the guys belonging to the official party in the States. They created the Reactionary International. I'll speak about it in a minute. Black Lives Matter. They promote Black Lives Matter. And Che Guevara. Of course, all right? So I was asking, how do we know that the Progressive International is related to the Sao Paulo Forum and to the Puebla Group? How do we know that? Because if you enter their website, very easy, look, the Progressive International, enter, and you click when it says members of the Council of the Progressive International, and you find these two persons. Mónica Valente, who is she? She is executive secretary of the Sao Paulo Forum. And Baltasar Garzón, my Spanish friends here know who he is, but he's the head of the legal team of the Puebla Group. So you have important leaders of the Sao Paulo Forum and the Puebla Group belonging to the council, to the directors of the Progressive International created by Bernie Sanders. Recently, they created the Reactionary International. And look what it says. It says, a research consortium on the illicit network undermining democracy across the world. That's what it says. I don't have time to explain what is this. I'm inviting you to investigate this. I'm leaving here my presentation and the slides, right, to whoever wants them. But the guys they're pursuing or they're going after, they're attacking and criminalizing, they write that. And it's Donald Trump, Jair Bolsonaro, it's Giorgia Meloni, of course, Viktor Orban is there. They have articles on him on that website of the Reactionary International. Of course, Santiago Abascal in Spain, etc., etc., etc. So, to answer Sebastian's questions, first, did the rule of law break down in Latin America? Well, many years ago. The consequences of that, the consequences is this. And now I promise I finish. You cannot have a country being suppressed like Cuba and thinking that because it's a very far island in the Caribbean, that won't impact in my life. If you let that cancer develop, it'll do metastasis in Latin America. And if you let that cancer develop, it'll do metastasis in the United States and in Europe. And this navigates on what? What is the power of those people to do this and to break the rule of law? Very simple. The destruction of natural law that becomes first, before, let's say, rule of law. First natural law, then rule of law. When you destroy the truth, when you promote relativism, which is what the left always does, when people cannot distinguish anymore on what is true and what is false, what is right and what is wrong, if a man can become a woman and vice versa or not, when you destroy the concept of eternal truth, which is valid for everyone, everywhere, in every continent, and at any time of the history of humanity, when you destroy that, then these monsters are able to grow and to destroy and to do metastasis, as I said. So afterwards, we'll speak about the solutions, but I will anticipate that it's very important that we fight the cultural warfare and to defend our principles, our traditions, our Judeo-Christian tradition of the Western civilization, because that is being under attack, and after you succeed attacking that, then you can break the rule of law or anything, because truth does not exist. Thank you very much.
Fred, that will be your turn. UK has been mentioned in the context of COVID. I know you will say some words about this, but I want to, again, take your time. The floor is yours.
Thank you very much, and thank you to Javier and Alejandro for two incredible speeches, which I don't think I'll be able to live up to, but they were marvelous presentations, which I learned a lot from. I knew it was bad in Latin America, but I didn't know it was quite so bad in Latin America, so thank you very much for telling us all about it. I'm delighted to be invited to speak and offer a British perspective on the threats to the rule of law and how it is breaking down, and how that is breaking down in my home country today. When I was first invited to speak at this conference, I thought I would have the opportunity to offer some thoughts and ideas that might be put to use by the Conservative Party before a general election in the autumn. Unfortunately, things have changed, and Britain goes to the polls on the 4th of July. I'm sad to say it looks overwhelmingly likely that the Labour Party will form the next government, and they will likely accelerate the damaging themes and the erosion of the rule of law that I'm going to explore today, and indeed everyone's been exploring in their own countries throughout this conference. It has not been broken yet, I don't think. Maybe I'm slightly optimistic to answer the first question, but it is certainly fraying, and I'm not particularly optimistic about the future, particularly under a genuinely left-wing government rather than the sort of left-wing, accidentally left-wing government we have right now. I'm neither a lawyer or a constitutional expert. I'm a political actor first and foremost, having served as a special advisor in the Conservative government working with Sir Jacob Rees-Mogg on his legislative and parliamentary affairs, and as well as working on Brexit and civil service reform. And I'm also a bit of an amateur historian, so do forgive me where I bring in a little bit of a British history lesson here, because I think there's some distinct issues about British history and legal tradition which is worth looking at here. So, on to the how, Sebastian's second question. Britain's tradition of rule of law is slightly different to Europe's. That doesn't need explaining in much detail to this audience, as you certainly all know. You will be aware of the common law, the ancient English conception of liberty, and the fact that we had, until the 20th century, an astonishingly lightly regulated and lightly governed country. A.J.P. Taylor's very famous and often quoted line about how little the British man of 1914 interacted with the state in his daily life, essentially the post office and occasionally the policeman, was true, and it highlighted a society which was at once highly liberal but also highly ordered and peaceful. But the demands of the wars of the 20th century ensured the growth of the state, which put unprecedented demands on the British people consequently. Conscription, the nationalisation of industry, the prying eyes of the surveillance state, and a war economy, essentially war communism, changed Britain forever. In the Ancien Regime and the Revolution, Alexis de Tocqueville remarked enviously at Britain never operating an armed mounted police force over its own population, unlike the much more authoritarian France. This is something we lost in the 20th century, I think, and never to return. And it has an interesting effect on the rule of law and the way it is felt by the public intuitively. Britain has had a tradition of implementing very few laws, simply and clearly written. There's a great elegance and clarity to Victorian law. If you do look through the statute books of the laws that we still do have on the books from the 19th century, and even in the medieval era, some laws are still in force, they are written beautifully simply, unlike the horrible consultation mess of European-style law we write today. And these laws were enforced fairly, robustly, and transparently, most importantly. Laws, once written and forced, come with great weight. They are delivered by an elected parliament, which is the supreme lawmaking body in the country. There is no higher authority than the higher court than parliament. That means that what laws we do enforce must be treated with utmost respect and severity. That is, of course, of great importance in England, considering our legal philosophy, in which supposedly everything is permitted unless it is explicitly stated otherwise in law. So Britain exists in a sort of regulated anarchy, rather than you have to have permission to leave the house, as you did in France and by written consent during the pandemic. That means to legislators to limit the liberty of the citizenry, and therefore it must be done sparingly and with absolute seriousness. With a remarkably homogeneous population and a unified national culture, whether that's from the kinship of the British people, a generally quite unified religious creed, our island geography protecting us from the wars of the European mainland, particularly the 30 Years' War, Britain was governed as much by assumption and custom as it was by law. You might be able to see where I'm going with this when we look at Britain as the modern Britain today, which is a multicultural nation, one which doesn't have quite the same assumptions holding it together. And this also is reflected in Britain's changing approach to legislation. It is neither serious, sparing, nor is it done with much regard for the populace's inherent liberty or the importance of their freedom. And this is where we see very many similar problems in Britain, as the other panellists today and speakers yesterday have talked about their countries in Europe. Today we have an increasingly undemocratic state, or rather the democracy we do have is quite cosmetic. We have a parliament full of parliamentarians who are unaware of their constitutional privilege and sovereignty, or even treat it with disdain, a political culture strangled by a legal web of rights which often contradict each other, and they entrench a progressive orthodoxy, and a regulatory state which insists on rulemaking instead of custom and enforcement in bans, and the regulatory state which increasingly operates against democracy and without parliamentary oversight. Most damaging of all is that the state has continued to grow and tries to regulate ever more of our lives. Its capacity to actually do so is weakening, and it is enforcing its laws unfairly, asymmetrically, and often in a way which feels arbitrary, where the law-abiding British population comes off worst. These issues are combining to create a crisis in the rule of law and a condition of anarcho-tyranny in the United Kingdom. Thing is, some people have been saying this is happening in Britain for a long time. This was first observed by Lord Hewitt, who wrote a polemic called The New Despotism. He claimed that the courts and the civil service were eroding parliamentary democracy and assuming de facto lawmaking power, and he wrote this as early as 1929. I cannot say whether it was true then. Probably wasn't true, but it certainly is true now. And four things have contributed to this, and I think the four things I'm going to discuss will point to the consequences, which addresses Sébastien's third question. The first one in the modern era is the host of Blair-era constitutional reforms, most significantly the Human Rights Act of 1998, but also the Constitutional Reform Act of 2005, which was addressed by one of the speakers yesterday, and the 2010 Equality Act. What these have done is they have eroded Britain's tradition of equality under the law as an individual and attempted to bring in separation of powers, an American or a European concept, not a British concept, and the rule of judges rather than by democracy. One thing that's been really quite pernicious, how it's developed in case law over the last 15 years, is what the Equality Act has done. That broke down the British people into 9 separate protected characteristics. What this means is you are no longer an individual. I am no longer Fred de Fossard, British citizen. In fact, I am Fred de Fossard who has, I might be able to grab one of 9 protected characteristics, and that can form my identity. So those will be race, those gender, religious affiliation, all that sort of thing. The most dangerous thing about that is that you stop being an individual and you essentially assume a group identity, which also, very importantly, can be a group identity you can claim solidarity with across the entire world. So it's a very anti-national concept as well as an anti-individualistic one. And naturally, we've been talking about the rule of lawyers. This has been a boon for lawyers because it's given us an entirely new legal industry, an entirely new web of making lawsuits, an entirely new way of suing people. So we've seen the growth of a sort of compliance and regulatory and legal state following these kind of regulations. The second issue has been the British state's response to the Brexit referendum. This was absolutely fascinating to watch unfold in real time. The referendum to vote, when Britain voted to leave the European Union, was the largest exercise in democracy in Britain's history. Yet, of course, you will have seen half our parliament didn't want to do it. Our regulatory state, our civil service, certainly didn't want to do it, and all manner of horrible tricks were thrown in the way, which eventually led to the sort of near explosion of populist anger, which was tempered and harnessed brilliantly by Boris Johnson's 2019 election victory. Of course, it's a bit sad talking about Boris's 2019 election victory because the promises haven't quite come true, but we'll touch on that later. But what it has meant is that we've left the European Union constitutionally. We are no longer bound by the European Court of Justice, which is fantastic. We are unfortunately still bound by the European Court of Human Rights, which is an ongoing issue. But we haven't rewired the British state accordingly. So, for example, our regulators. We have two big regulators that I write about a fair bit. One, the Financial Conduct Authority, which regulates our financial services, and two, the Competition and Markets Authority, which is our antitrust regulator. When we were in the EU, these bodies worked within the context of the EU, where they basically responded to the European Commission and British Parliament had nothing to do with it. That was not democratic, but that was how the European Union worked. We have now left the European Union, but these bodies act as if we never did. And this is steadily causing a rule of law issue, if not crisis, certainly a rule of law problem, because these bodies, which essentially have law-making power, particularly the FCA, which literally makes policies like it's now trying to mandate diversity quotas on private companies working in the financial services sector, these regulators are able to do this without parliamentary oversight. And this is hardly the sort of deliverance of taking back control on which the British people voted for when they voted to leave the European Union. Indeed, this is where the real rule of law crisis comes in. It is not a Conservative government trying to prorogue Parliament to deliver the Brexit referendum, but in reality it is a failure of our entire regulatory state, the civil service, Whitehall and our political class to actually deliver Brexit, which is the real root of the rule of law crisis. As I said earlier, we regulate, we legislate, and we don't even have the capacity to enforce these policies. In the area of criminal justice, for example, we introduce new sentences all the time, new special convictions. You can have a special sentence if you kill an emergency worker. So you're not just sent to jail for murder, you're sent to jail for killing a paramedic. Obviously, killing paramedics is very bad, but I don't think it needs to be a separate type of illegal offence. But then, of course, we don't even have enough prison space to put people in jail. So on the one hand, we do a round of tougher sentences, and on the other, we're actually letting people out of jail because we haven't built enough prison capacity anyway. So and if you're a member of the public, you will suddenly realise these things don't match up. This is where the rule of law begins to break down, because we see the state talking tough on one side and not delivering at all, and in fact acting in the complete opposite way. And this will steadily erode trust in the criminal justice system and the British state as a whole. And now onto the pandemic, which we've touched on a little bit, and the way in which Britain decided to enforce its lockdowns. Now, of course, I've mentioned earlier parliamentary sovereignty. It is the supreme lawmaking body in Britain. And some people accuse Conservatives of wanting to be a sort of authoritarians with Parliament, treat it like an elected dictatorship. So I'm not going to say the Parliament should have unlimited powers to act to erode the liberties of the public, because certainly the way it behaved during the pandemic was extraordinary. It passed the legislation to put us into lockdown in one day. It passed hundreds, possibly thousands of secondary instruments, often without a vote, which then continued lockdown measures, banned certain businesses from opening, and we all remember the pandemic, and we all know how terrible it was. Indeed, there were no human rights concerns raised during the pandemic. The web of sort of left-wing lawyers who will always campaign on behalf of criminals or asylum seekers or illegal immigrants about their human rights if we want to try and deport them were remarkably silent about the human rights of the entire population when we put them into lockdown, which I did find rather extraordinary. The police forces acted in a tyrannical way. There was one extraordinary example of Derbyshire police force in the early days of the pandemic sending drones up into the Peak District, a beautiful stretch of countryside in the Midlands of England, and filming people going for walks, saying that is not essential, you need to go back home. And they blasted this all over their social media. And it was an extraordinary example of a police force getting high on their new powers. And I don't think they have recovered the public trust ever since. And the lockdowns then leads me on to my next point, which I think is the most pernicious, which is the way the state has handled different types of protests since 2020. While the entire population was locked inside, Black Lives Matter protests happened in May 2020. the police did nothing to stop them. Indeed, many police officers took the knee in front of Black Lives Matter protesters who protested down Whitehall, which is the main street of the British government. Then, of course, we've seen since last year the way in which the police have handled the pro-Hamas demonstrations in London. With light touch, to say the least. The police at one point decided to equivocate over whether calling for jihad was a crime. And indeed, at one point, one of the official police Twitter accounts said there are many different meanings of jihad, and we don't know whether they were calling for holy war or just talking about the sort of personal struggle meaning of jihad. So therefore, no offence was committed and these protesters were allowed to continue. Yet, of course, when Remembrance Day came along on the 11th of November, a Palestine protest was planned for that day. That is obviously the time when we remember the fallen in the First World War and all other wars. So a group of patriotic counter-protesters decided to plan a march and stand around the war memorials to protect against potential threats of vandalism, which happened in the Black Lives Matter protests 3 years before. The police arrested all of them. They arrested all of them under the breaches of the King's Peace, which essentially means that if you're going to cause trouble and other people might want to attack you, we will arrest you because it's easier to arrest you because you're a small group and they're a much bigger group. And to be honest, they're a much more politically connected group and they have a much bigger web of sort of activist lawyers, campaigning organisations to campaign on their behalf, whereas the sort of ragtag bunch of right-wing football hooligans certainly don't have that kind of sort of lawfare infrastructure behind them. So I think that was an extraordinary moment where we've seen the annihilation, or we are seeing the annihilation of trust in the law, because we're realising quite quickly that it works in favour of some people and not in others, and we are certainly not treated as individuals equal under the law. So I do think this is going to get worse, and it will especially get worse if we have a Labour government, which it looks likely we will in July. The leader of the Labour Party, Sir Keir Starmer, is a human rights lawyer and a civil servant by trade and by instinct. And his human rights lawyer instincts really do go deep, and it's how he sees the world, it's how he sees the country, and it's how he sees his approach to injustice. His instinct is always to support the supposedly marginalised against the democratic will of the nation. Just see his party's approach to the British government's attempt to finally get on top of illegal immigration. Indeed, he campaigned and put his name to a letter against the deportation of a group of foreign criminals to Jamaica in 2020. That deportation flight fell apart because of the political campaign waged by him and many other Labour MPs. And then one of the men who was due to be deported then went on to kill someone. So it's a really interesting, it was really perfect analogy of how we have the democracy of wanting to control our borders and keep our nation safe is being subverted by this lawfare culture. Another thing he will do, which will damage the rule of law, is he is likely to continue Gordon Brown's constitutional vandalism. He will erode democracy further with a plan, apparently, to ask the Supreme Court to adjudicate between disputes between the House of Commons and the House of Lords. If we do that, then we are going to find ourselves in very much an Israeli situation where the Supreme Court and the chairman of the Supreme Court essentially becomes the real king in Britain, if they are the only person able to judge between a dispute between the two houses of our legislature. Furthermore, they've suggested they might introduce things called citizens' assemblies, which is entirely outside Britain's tradition of policy making, where the state and civil society and NGOs will handpick a group of 100 citizens to agree thorny political issues, and we can imagine what their conclusions will be, and then they will become law. So I do think dark times are ahead. The Conservative Party and the British Conservative movement very much needs to think on why it failed in office to protect the rule of law and to obviously deliver its promises to the public. And it needs to have a sort of constitutional reformist or perhaps constitutional restoration movement. Especially as I think that this will be on fertile territory, as I think the trust in the rule of law will genuinely begin to collapse, and it will destroy the entire concept which we have spent the last 1,000 years building. Thank you very much.
Well, that's challenging to continue after 3 captivating interventions like these, but thank you, gentlemen, for that. Now, the idea is to talk about the solutions, and my proposition would be to start with maybe something which will sound obvious, but what we partly did here is sort of diagnosis with the individual countries, the situations presented. We diagnosed that the situation is far from encouraging. I personally don't have many ideas how can we fight back, given the scale of the backlash on democracy, on common sense, and so on. I have the feeling that partly the source of what we are experiencing today can be traced from a mentality of the French Revolution. And more precisely, one of the slogans of the French Revolution, namely, there is no liberty for the enemies of liberty. And I think from the four stories that, for the four cases we outlined, this is what can be observed. And if we think about it, this sentence is the summit of intellectual contradiction. Because how can you, who decides who is an enemy of liberty, right? You knew Alejandro by yourself, you said they have nothing against me. But in fact, you are, I believe, from a communist Venezuela point of view, an enemy of liberty, aren't you? So this twist of mind which basically denies objective truth. I think this is one of the, from a, let's say, an intellectual point of view, one of the threats. When we deny objective truth, we have a hard time fighting back. I have a short anecdote to tell you. I was once invited to, I think it's called interfaith dialogue meeting, where you have representatives of different religious groups and free thinkers and so on. And they introduced themselves, one by one, and in the end they said the conclusion of our meetings, we meet every Tuesday night, is everybody has his or her own truth. And you're welcome to join our club anytime, but this is the one condition. We have one condition, one golden rule. You have to accept that everybody has his or her own truth. So after a moment of thinking, I raised my hand and I'm like, excuse me, gentlemen, because they were, in this case, only men. I have a question. If my truth is that there is only one truth, am I welcome in your club? And they got angry. So it didn't go far. But coming back to our discussion, something again which maybe sound obvious, I think we should unite. We should unite. What our opponents have in common is that they distort reality, they are intellectually dishonest, they use force rather than arguments, and so on. Uniting is one of the things we should do, and fighting back completely. The cultural war has to be fought back. And now I give the difficult part of the answer. How do we do that? And here I give the floor to you.
I will start with a British solution. This isn't applicable to other countries because of Britain's constitution. But one thing we should do, the first answer is is essentially purge and rebuild the Conservative Party. It's a shame that the party I'm a member of and served in government is responsible for so many of the problems we have. But for the time being, with our electoral system, the Conservative Party remains the vessel for the right, so that has to be reformed. When it comes to policy, I think the British Constitution does hold some advantages. For one, no parliament can bind its successors, and parliament remains the most supreme lawmaking body. So even though we do have a Supreme Court, it can't actually overrule parliament. So what I would recommend doing, you legislate to repeal the 2005 Tony Blair reforms. You either abolish the Supreme Court and bring it back into the House of Lords where it used to sit, or if you want to keep it separate, you rename it the Final Court of Appeal or something like that, because by calling it the Supreme Court, you basically politically create the idea that it is above parliament when it is not. So it has to be at minimum renamed the Final Court of Appeal, or ideally brought back into the House of Lords, and that restores the British tradition of proper a democratic approach to law. I think that's one important step, and you should do the same thing with repealing all of the other pieces of constitutional vandalism that I mentioned in my speech. So there's a legal answer, but that can only come after the reform of the most likely political party to do that.
Well, regarding Spain, I think we have an answer that may be, I'm coming from Spain, but my answer may be applicable to more countries and not only Spain. Let me explain that. Before answering, I think this question requires for me a couple of observations. As I said at the beginning of my presentation, my main concern is nation integrity. Spain is facing, at the present moment, a terrible denationalization problem which is being promoted by its own state. Spain is facing a process of federalization that threatens its nation integrity. And a kind reminder on this. The destabilization of Spain has historically always been a first step towards the destabilization of the rest of Europe. Now, addressing your question, Western governments and legislative houses are no longer working for their national interests. They are working for someone else's interests. And if there is a buyer, that is because there is a seller. And I think that the biggest corporations in human history are buying countries by means of buying little men while they are holding temporary offices in their own respective countries. We are witnessing, I think, the greatest collusion of all times. It has already killed modern state, as I said previously. And what's next? They are already telling us that what we can perceive may not be what is really happening. I mean, reality is being labeled as disinformation. But don't lose your heart, because I think that the death of state is a piece of good news after all, because it allows a new beginning, a moral reset in opposition to the Great Reset promoted by that advertising and lobbying company called World Economic Forum and all political and private players behind it. Western nations need a moral reset rooted in these four core elements of civilization and culture. And following your recommendation, Sébastien, I will repeat them. Life, self-defense, property, and transcendence. The four are nation-born. None of them come from the state. But make no mistake, ladies and gentlemen, following Rudolf von Jhering, the breakdown of the rule of law is the breakdown of peace. And then, following this, we can say we are at war. A bloodless war for the time being, but it is a war in which weaponized legislation with a pink-collar terror regime as destination. A war in which dying states fight their own nations in the benefit of third countries, supranational entities, and private corporations. And in this war, life is pursued, self-defense is forbidden, property is a dead body, and governments are priests. We need a new rule of law, starting with these four constituents for individual freedom. A rule of law developed in harmony with them. After all, a moral reset.
Mr. Alejandro, would you like to add something?
Yeah. I will also start like you with an anecdote, with a story. I organized the first street protest against Hugo Chavez. He didn't put me in jail for that reason. I accused him formally at the attorney office of treason because he was related to the Colombian guerrilla, narco guerrilla, and he was related to the tyranny of Cuba. So I accused him of treason. He didn't respond to that. But when I started traveling through Latin America, contacting conservative forces to build an anti-Sao Paulo forum, then he put me in jail. That was the reason. And why do I tell this anecdote? Because the left is conscious that they're not as strong as the right. They don't have the same commitment. They don't have the same morality. They don't have the same right ideas. They're weaker than us. But they're stronger because they're articulated and we are not. And when I say they're articulated, I'm talking about on a daily basis. Let me put an example. They have this journalist organization, Albino Mario. They have this organization which on a daily basis, they analyze everything that happens in the world. The center is in Havana, Cuba. They see what happens in Europe, and they write a response, right? And the response, let's call it the line, the discourse, they send it to other assets in all 5 continents, and they all respond the same every day in different newspapers and different outlets, different media, different social networks. They are articulated in a daily basis. It's not that they meet once a year, no. Daily basis. And we are not. I think that one solution is to understand that in this fight, we're not alone. It's not even a chessboard in which we have an adversary and we're playing in that chessboard. No. This is a boxing ring. And you have to study your adversary. The guy is going to try to knock you down. What does a boxer when he's going to fight someone? He sees all these previous fights, the films, you know. He studies the person. He knows how he studies the weakness. We don't have that. We have to have an articulation on a daily basis to understand who is our enemy, how does he work, what are their strategies, and we have to do the same. In other words, if they have the Sao Paulo Forum, the Grupo de Puebla, and the Progressive International with their strategies, we have to build a mirror organization, and we have to fight them in every part of this warfare. That's just a short answer to something more complicated. Thank you.
Thank you so much. I wish we could elaborate on this, but the clock is ticking. So Alejandro, Javier, and Fred, thank you so much for this very interesting exchange. Thank you to everyone. And once again, I ask for your applause.
Ladies and gentlemen, welcome back. Thanks for joining us. You are sure not to be disappointed by our final panel. I look forward very much to hearing their remarks on the Anglosphere and human rights. I'll let our president, the Danube Institute's president, introduce the panel.
Thank you very much, Mr. Chairman, ladies and gentlemen. I'd like to say it's a great pleasure to be talking to you, particularly after such a conference as we've already held. But it has its bad side too. This has been a very enjoyable experience, darkened for me only by the knowledge that the present moment was bound to arrive, and I would be bound to be shown to have not much knowledge of law or culture, and also an inability to benefit from the inspiration of the moment. The science has established that the human brain starts working from birth and continues doing so right up to the moment when someone rises to make a public speech. But I look forward to having survived this introduction and enjoying the contributions of my extremely distinguished co-panelists. The debates today are and have been very necessary, if sadly so. In all the nations of the Anglosphere, with the partial exception of the United States, law was until recently a political battleground, mainly at the stage of electoral debate and parliamentary lawmaking. The courts very occasionally had to make judgments that had serious political or constitutional implications. But there was generally a common understanding that decisions of the court made law that made law, rather than merely interpreting it, could be reversed by the legislature, and the legislature's decision, like that of an editor, was final. All that has changed in recent years with the Human Rights Act in the UK, the Mabo decision in Australia, the growing power of the Supreme Court in Canada, where they are known as the Supremes, and in the United States too, where the court has taken to discerning constitutional rights founded solely in the musing of its members on the meaning of life. In the great majority of these decisions, the political direction of change has been leftwards, and their political content has been supplied in great measure from ideas and values floating about in the mainstream of the cultural atmosphere. The cultural atmosphere is not drawn, however, from the beliefs of the whole of society, or even of a majority of its citizens, but as the late Robert Burke complained bitterly, from the mindset of the academic media philanthropy complex that has metastasized since the 1960s, and that is now replaced the military-industrial complex as the dominant ideological force in political life throughout the Anglosphere. So we have to make a case for returning lawmaking to democratic and accountable institutions like Parliament from the courts, and in order to achieve that, we have to make arguments within the legal community that unmask, resist, and counter the proposals for major political change that come in disguise as legal reforms or constitutional necessities, or sometimes as the unanticipated consequences of a myriad of minor regulations. The liveliness of the debates at this conference tell me that you're all doing a fine job on those. Let me turn now to the ways in which culture and law interact in a way that is damaging politically. First, there are three ways, I think. First, how a multitude of regulations, if their growth is unchecked, risks creating a passive and dependent population. Second, how the attempt to change social beliefs by law and regulation ends up pardoning the criminal and stigmatizing the respectable. And third, how the postmodern belief that truth and justice are merely masks for the exercise of power creates an ideological tyranny. First, the explosion of regulations that the administrative state produces. I'll begin with a parable from John Donaldson, who a few years ago became the BBC correspondent in Australia, and I think it was his first broadcast, told the story of how he was stopped by a policeman, then threatened with a court appearance, and then fined $51 for walking across the road against a red light. The policeman told him, "The courts take jaywalking very seriously." Jonathan concluded, "The laid-back, easy come, easy go, throw another shrimp on the Barbie stereotype of Australia is encapsulated in the vibe of its unofficial anthem, Waltzing Matilda, where a swagman pinches a local sheep for his supper. In reality, these days, our jolly swagman would probably be pulled up for pitching his tent without a proper permit, lighting an illegal fire, and sparking up a cigarette in a public place. Australia," he said, "is without doubt one of the most rule-obsessed and bureaucratic places I have ever lived in." Now, ladies and gentlemen, if a BBC correspondent criticizes Australia for doing something like halting immigration and stopping the boats, well, he's simply doing his job. But if he says that Australia is more restrained by regulations than a blonde in a bondage magazine, then he must have noticed something real, something indeed unavoidable. And what Mr. Donaldson is onto is something that is more damaging in practice than in theory. Regulations like those to which he drew our attention are generally not objectionable in themselves. Some may be too costly for any benefit they bring. Some may be too intrusive for their applications. Some may not achieve their objectives. But they are intended to protect us from contaminated foods, poisonous liquids, financial fraud, and any number of other risks, all of which reflect a reasonable cultural preference not to be poisoned or defrauded. Their bad effects stem from their number, their freedom from effective democratic control, their uncontrolled multiplication, and their growing influence on ordinary citizens, telling them to be too nervous of risks and too demanding of protection. Regulatory expansionism gives bureaucracies too much control of our lives, and it breeds an unhealthy dependency in the general population. And when I mention dependency, I'm not talking about welfare dependency. That is a bad thing, too. And it's made worse when the regulations surrounding welfare benefits offer perverse incentives. For example, for single mothers to break off relations with the fathers of their children. But the dependency bred by excessive regulations in the general population is a more general passivity. We are encouraged by over-regulation to rely more and more on government officials to do for us what we could equally do for ourselves. And maybe more important, telling us what not to do that might help us to solve our own problems. And the authorities themselves come to believe that they should enjoy a monopoly of action in areas where health and safety are concerned. In Britain, in recent years, that has led to some extraordinary interventions by the authorities on what common sense suggests is the wrong side. In one case, police prevented by physical force men attempting to rescue 3 children from a burning house on the grounds that they were not trained to do so. They were forced to wait for the arrival of firefighters, who, alas, arrived too late and the children died. There have been several such many such perverse official interventions, which have made health and safety in British life a popular synonym for cruel idiocy. Richard Littlejohn, the Daily Mail columnist, has made a specialty of writing about such occurrences, and he has probably achieved more in fighting this general trend than the entire Conservative Party. Now to the second set of ill effects. These are produced by laws and regulations that stem not from the cultural beliefs of society, but from the cultural beliefs of those in and out of government who want to transform society radically. As common sense, which is the first target of such reformers, would suggest, a policy of transforming the beliefs of most citizens by law is going to require much more coercion than one where the regulations reflect popular opinions rather than countering them. We know more about how such experiments end up from abroad more than we do from Anglosphere countries until recent times. I mean, the earlier examples are such experiments as the attempt to create new Soviet man, Aryan man, and even Yugoslav man. These all failed. I recall one of the first political speeches I heard, the late Colm Brogan, a brilliant satirical journalist, rejoicing in the stories of drunkenness and idleness that were then filtering out of Moscow in the 1960s. They were happy proof, he said, that the old Adam had triumphed over the new Soviet man. Our cultural revolutions in the Anglosphere were, until recently, very tame affairs. They went most obviously under such names as multiculturalism, biculturalism, affirmative action, and more recently, wokery, which has become more threatening, tearing down statues and marching in support of genocidal anti-Semitic slogans. Such cultural revolutions try to redefine such matters as national identity, to drain them of historical content and to turn them into safe, social democratic concepts like mutual distribution through taxation. They identify such new evils as institutionalized racism and conduct campaigns against them. And campaigns, too, against those unfortunates in their grips, such as the police or the white working class. They arrange a hierarchy of rights in which, say, gay or feminist rights trump the right of a religion to employ believers in sensitive posts. They undermine traditional markers of identity, virtue, and patriotism by treating them as racism, or worse, and they stigmatize whole social groups, such as blue-collar workers, who are seen as the hotbeds of socially conservative bigotry. But the wholesale transformation of society and social values wants to go far beyond these obvious political moves. It seeks both more wholesale and more subtle changes in social attitudes. To illustrate this, I want to cite a judicial quotation, once a well-known one among lawyers. It's a quote from a legal judgment in court about a man who had jumped into the River Thames for fun and for a bet. But as the court discovers, he doesn't seem to have broken any known laws in doing so. And the judge says that he has obviously done something wrong for which he has been most properly punished, but the judge can't quite work out what it is. And here's the full judgment. I think there is I think we have it here. Oh, sorry, it's the previous one. What do I do to get it go back?
Is it back? It is Principle of English Law?
Sorry? Oh, this is the one I want, yeah. This is the judgment. It is a principle of English law that a person who appears in a police court has done something undesirable, and citizens who take it upon themselves to do unusual things which attract the attention of the police should be careful to bring these actions into one of the recognized categories of crimes or offenses, for it is intolerable that the police should be put to the pains of inventing reasons for finding them undesirable. An American legal textbook in the 1960s said that this is a rare case of the English courts writing new laws. Well, of course, it wasn't quite that, because it is in fact an extract from a legal satire. Those of you who are a bit older will remember A.P. Herbert, who in a series of books called Misleading Cases provided what seemed like genuine legal Times law reports, but were in fact parodies of them. So, of course, the American critic said, no American court could ever reach such a verdict. Well, in fact, of course, no English court had either. It is not a principle of English law that someone who appears in a police court must have done something undesirable. But it was, until recent decades, a principle of English culture. That principle was entitled respectability. Philosophers and theologians looked down on respectability as a tepid imitation of real virtue. Virtue consists of doing good when no one else is looking. Respectability consists of doing good because other people might be looking. Samuel Butler replied to critics of respectability in Era 1, pointing out that those who rejected respectability as an inadequate version of virtue were usually the very same people who never managed to live up to its unexacting standards. Now, appearing in a police court definitely violated the tenets of respectability in the England of my youth, and doubtless in England, and doubtless in America and Australia, and particularly, I think, New Zealand. But if you are changing society, then you must either invert respectability or undermine it. Thus, we gradually find ourselves reversing what society treats as vicious or virtuous. A new progressive lumpen intelligentsia, from kindergarten teachers to critical legal theory lecturers, become the vehicles for transmitting these new orthodoxies to ordinary citizens on a daily basis. Under this transforming officialdom, respectability becomes a middle-class privilege, and thus itself a stigma. At the same time, the stigma of appearing in a police court, even of being convicted, is reduced or made to disappear entirely. Look at what Soros's DAs are doing in the United States. Crime becomes a sign that society has offended against the criminal. In order to avoid the appearances of being either enforcers of middle-class interests or gripped by institutionalized racism, the police become the paramilitary wing of the Guardian. Initially, at least, parties of the left are generally the carriers of these ideas. As my late friend from the Daily Telegraph days, Frank Johnson, said of the UK Labour Party, they can't nationalise industries anymore, so they nationalise people instead. But after a while, soi-disant progressive members of centre-right parties tend to go along with these ideas as well. And politics slowly evolves into a battle between progressive forces, different progressive forces, that seeks to impose these new versions of respectability on conservative citizens who have to puzzle out what is going on before they can effectively resist this indoctrination. Much follows in train. Social legislation on such matters as gay marriage, gender parity, or ethnic proportionalism is passed with only modest resistance because many, or even most people, see the new laws as essentially liberal measures expressing a live and let live attitude. It then turns out, however, that the new laws also demand changes in the social attitudes and opinions of those who still resist the original reforms. Live and let live is replaced by the enforcement of public conformity. Speech opposing or criticizing such measures is increasingly regulated, therefore, sometimes in extravagant ways. Thus, Christian bakers have been compelled by the courts not merely to sell cakes for same-sex weddings, not itself an unreasonable application of anti-discrimination law, but even to inscribe words celebrating same-sex marriage on the cakes which are contrary to their own beliefs. Official housing agencies in America have sought to criminalize political opposition to social housing problems as racist and therefore claiming powers to ban public meetings called to resist the new measures. New crimes are created and ordinary citizens are penalized for expressing traditional social or religious attitudes. A former minister in Finland is now facing, I think, her third trial for quoting the Bible. But whenever some conventional crime or social evil emerges as a major political problem, for example, something like public drunkenness of young people, the notion of punishment disappears. Legal and police authorities propose to deal with it by raising the price of alcohol or running health campaigns aimed at middle-aged home drinkers. In response to violent crimes, the police warn, in quite strong terms, ordinary citizens from having a go to protect their property or to save others from attack. They suggest, rather, that ordinary citizens should invest more in burglar alarms. In short, the regulation of the law-abiding replaces the punishment of criminals as the criterion of wise public policy. And when ordinary citizens resist or intervene against ordinary criminality, and if their actions cause the death or injury of the criminals concerned, the police are much more zealous about prosecuting them than in pursuing the crimes of burglary or robbery that caused the fracas in the first place. 4, more punitive attitudes take over when vigilantism, race, religion, or sex are at issue, since these are seen as the battlegrounds of government-mandated social change and the popular resistance to it. Thus, the US government knowingly propagates the use of false statistics that greatly exaggerate the incidence of rape on college campuses. And it is seeking both to remove the traditional procedural protections for defendants of certain crimes, one is rape, but not the only one, and to make its definition cover a far larger range of sexual activities. Similarly, the Crown Prosecution Service in the UK has called for higher rates of conviction in such cases and issued new instructions for the jury to bring this about. These measures reflect the feminist belief that rape is a less rare and brutal crime than more or less it is the extreme end of male sexual behavior in general. But of course, if these changes are implemented wholeheartedly, they are likely to confirm that view by generating, among other things, more false rape convictions. Nor increasingly are ordinary citizens even allowed to opt out of government-mandated social attitudes. There is currently a serious campaign supported by governments and NGOs in Europe and in America to remove any right of conscientious objection by doctors and nurses to performing abortions. Abortion used to be a crime. It is now in many countries an individual right, though one defended as safe, legal, and rare, and regulated. In this proposal for restricting conscientious objection, however, abortion is being treated as a public good, and if the proposal succeeds, it will effectively compel pro-life doctors to leave obstetrics and other medical specialisms for other forms of medicine. What makes this process of inverting respectability treacherous even for its practitioners, let alone the perplexed majority, is that no one can depend upon the new progressive conventions staying upside down. The 2007 UK documentary for Channel 4, Undercover Mosque, demonstrates this almost too well. Hidden cameras recorded imams in 6 British mosques calling for the execution of homosexuals, the murder of Jews, the bombing of Indian businesses, the deaths of British soldiers in Afghanistan, a jihad against non-Muslims in England, child marriage, hitting young women who refused to wear the hijab, and much else contrary to laws against inciting racial and other hatreds. On being given this video, the West Midlands Police proposed to, quote, give equal priority, unquote, to prosecuting both imams and documentary makers. After watching 56 hours of video footage, the police and the Crown Prosecution Service then concluded that neither could be prosecuted for lack of evidence, but that the documentary had edited the imam's comments unfairly out of context. As always with that excuse, one wonders what context could have made these murderous comments reasonable. No matter, the imams were, for the moment, out of legal peril. At which point, the police continued the pursuit of the documentary makers, referring it to Ofcom, the official television regulator, for inciting racial hatred and undermining community safety. Even after Ofcom rejected the complaint out of hand, praising the documentary's fairness, the police persisted with their attacks on the programme. This went on against a background of increasing controversy until the police were forced to withdraw, apologise, and pay a large sum in settlement following an action for libel mounted by Channel 4, which, by the way, is quite a left-wing channel. How on earth could this list of absurdities happen? Incitement is a form of speech that can attract calls for legal restraint, usually on the grounds, reasonable ones, that it might disturb public order or provoke violence against individuals. Expanding that concept, however, has been part of a general political campaign to smooth out the difficulties of the multicultural society and to discourage opposition to its further progress, as, for instance, campaigns to restrict migration. Undercover Mosque exposed a contradiction between these two purposes. There is little doubt that the imams were guilty of inciting racial hatred under any traditional interpretation of preserving order and free speech. By pointing that out, however, the documentary makers were guilty of undermining community cohesion and multiculturalism. It took a lot of wriggling, but the police and the CPS plainly show that they preferred the second argument. If the plain facts of the case had not been on the side of Channel 4 and Ofcom, that preference might well have prevailed. Community cohesion, avoiding bias, and other catchwords of multiculturalism are powerful juju in modern progressive bureaucracies, including those customarily thought to be conservative, like the police. The Brits saw their mystical power in the recent urban scandals, in which the police and local bureaucrats more or less collaborated with gangs of Muslim rapists to coerce young white working-class girls into prostitution from fear that accusations of racism would be levelled at them by community leaders. Australians have learned still more in the past too, as in the Martin Place siege. The police, Sydney police, seem to give at least equal priority to avoiding bias crimes against Muslims as to saving the lives of the hostages. As the television detectives say about serial killers, there's a pattern here. And with every step in this progress, ordinary citizens become more alienated and hostile to the society that they once felt was home. At best, they will withdraw into a private place. Social evils grow, but the authorities are psychologically unable to tackle them seriously. Eventually, people rebel, and official social transformation meets more determined resistance. Whether that social transformation then comes to an end or resumes after a pause, we don't yet know. That is the situation in which we are now living culturally in relation to crime, human rights, and punishment in all of the Anglosphere countries. Now, having set the ground there, let me now invite our three speakers to respond with their own ideas on this topic. First, I think David McGrogan, Associate Professor of Law at Northumbria Law School. David, and after you, I think, Hadley Arkers, and after you, Jonathan Price.
Hello, everybody. I'm here to say the least controversial thing that a conservative can say to another group of conservatives, which is that the future looks bleak. I'm just going to explain briefly why that is. So my topic is the small topic of the trajectory on which we find ourselves as we head towards the end state of liberalism, and indeed of modernity as such. It's not an easy topic to deal with in the course of a few minutes, but examining developments in the field of human rights will help us to achieve that objective. This is because, as the most perceptive of leftist critics have always argued, human rights are fundamentally a technology of liberalism. They produce the liberal subject. By examining the type of subject which human rights produce, we therefore understand better the liberal future that awaits us. Let me then frame our discussion by asking what the past decade has taught us about what human rights law is really for. And here I'll borrow a technique developed by a Hungarian, although he lived for most of his life in France. None of us is perfect. Anthony de Jassé. De Jassé observed that if we want to understand the state, it helps to imagine it as a person, with objectives, desires, and motives. So let us then, taking a leaf out of his book, imagine that human rights law is a person. And let us therefore examine human rights law as though it had motives and desires of its own. What, looking at this person's behaviour, as made manifest in court decisions and in the activities of activists and campaign groups, can we glean about his or her project? Well, certainly securing freedom of speech does not appear to be on the agenda. Human rights law seems to be intensely relaxed about censorship. Certainly it is not for the elimination of discrimination as such. Human rights law appears to be quite happy about discrimination, as long as it can be understood in a positive sense as leading to the goal of substantive equality. And certainly, as we saw in 2020 and in 2021, it is not particularly interested in civil liberties. The rights to freedom of association, to freedom of conscience, to bodily autonomy, and indeed to liberty itself. Those things human rights law easily and readily sacrifices. On the other hand, human rights law appears to be very concerned about the rights of illegal migrants. It appears to value substantive equality, meaning equality of outcome, very highly. During the pandemic, its chief concern appeared to be protecting the most biopolitical of matters, not just health, but life itself. Human rights law, as we have recently seen in the jurisprudence of the European Court of Human Rights, is also extremely worried about climate change. And it is very keen that there should be no diminution in the size and scope of the welfare state. Those things are the things which human rights law cares the most about. Thinking of human rights law in this way, as though it is a person with a will and a consciousness, therefore helps us very easily understand what its purpose is. And holding it up for examination in this way, we see that this purpose is absolutely not the limiting of the power of the state. Far from it. Human rights law's chief concern is rather to facilitate the expansion of the scope of state power to each and every horizon, to bring within its purview not only the means of human subsistence, not only the substantive equality of each and every individual human being, not only the populations of every part of the globe, if they are able to make the physical journey to a human rights respecting location, not only sickness and disease, not only even human life, but the very climate itself. There is no aspect of economic, social, cultural, or naked biological life that is beyond its ambition. Human rights, then, is a technology of liberalism par excellence, if we understand liberalism not as a limited form of government, but rather as how Leo Strauss described it, as that form of government which promises complete emancipation within the universal and homogeneous state, a state in which all are made equal, all are freed from conditions of want, all are liberated from nature itself, and all human difference is made politically irrelevant because all are secured in the mutuality of recognition. Strauss was, of course, commenting on the thought of Alexandra Kojève, but it's through another Straussian sparring partner, separated by centuries of time, to whom we must turn to properly understand this phenomenon, namely Niccolò Machiavelli. Strauss presents Machiavelli to us as the central figure in the break between modernity and what came before it. This is because Machiavelli represents an understanding of government as being grounded only in temporal justification, never theological justification. The practice of modern government gets its legitimacy and its justification from the fact that it precisely governs, it acts upon the world. For Machiavelli, this meant modern government can be understood as a relationship between governor and governed, in which the former must at all times govern in such a way as to secure the loyalty of the latter. Without that loyalty, the relationship would break down and the governing framework would collapse. The modern state's obsession, then, would be to govern in such a way as to retain the population's loyalty. And those familiar with Machiavelli will know that he believed there were only two ways in which that could be realized. The state could represent the norms and the virtues of the population as a republic, as a moral association, as Hadley referred to it yesterday, or it could rule the population as a prince. In a republic, loyalty is secured by the connection between the government and the people. In the principality, loyalty is secured by the purported necessity of government, without which the population will decay into corruption. The rule of the prince, then, relies on a discourse through which the population is constructed as vulnerable, needy, and decadent, incapable of being left to its own devices, and incapable of governing itself. Government justifies itself in this model through a portrayal of itself as indispensable, since the people without it are corrupt. In chapter 6 of The Prince, we see this stated very succinctly in the course of a single sentence. It was necessary, Machiavelli tells us, for Moses to find the people of Israel slaves in Egypt and oppressed by the Egyptians, in order that they might be disposed to follow him to escape this servitude. Note the emphasis. It was necessary for Moses that the people of Israel were in a position of vulnerability, destitution, and enslavement, that he might be the one to free them, and that they might therefore be disposed to follow him. This is in essence the promise which the modern state and modern liberalism, which increasingly rejects the concept of representative government, makes. Trust in me and let me lead you, because without me all is chaos. You, the people, cannot be trusted to govern your own affairs, cannot be trusted to cooperate with one another directly, and cannot be left alone, because to do so would be to give effect to your corruption. It is I, the state, who can free you from want, who can deliver you to a position of perfect equality, who can liberate you from any and all constraint, who can protect you from sickness and death, and who can even protect you from the climate itself. This is the reason why I exist, why I govern, and why I should retain your loyalty. I won't belabor the point which should by now be clear, which is that human rights law in its current iteration functions as the quintessential tool of liberal political reason. What I mean by this, and those familiar with the work of Michel Foucault will recognize as I borrow his language, is that human rights law functions to justify the exercise of government in the liberal mode. It provides a reason or a set of reasons why a liberal governing framework should exist and perpetuate itself. And it should also by now be clear as to the type of human subject which human rights law produces, and the type of relationship which that human subject has towards the state. One of total reliance, in which the individual is liberated, equalized, made secure, and morally improved by state power, and in which, by extension, the total merger of state and society, wherein the justification for the existence of government will never be questioned, is ultimately realized. That is the trajectory on which we travel, and it is that project for which human rights is the vanguard. Elaborating the substantive nature of that end state is beyond the scope of my comments here, but I dare say you will see it play out in due course. And with a closing remark to follow on from John's, we will see it emerge, I think, very quickly, starting on, ironically enough, July the 4th of this year, when the UK will, I think, undoubtedly elect a Labour government. And this will be a Labour government which will complete the project that was begun by the previous Labour government. When Tony Blair was the Prime Minister, he said he intended to make the Labour Party the political arm of the British people, right? And he intended to do that through human rights law, under the banner of human rights law. Keir Starmer will complete that process, and so we will watch the consequences unfold, I think, very rapidly indeed. Thank you very much.
David, thank you very much. Hadley, and if you, yeah. Hadley, you've already met, so I don't have to really introduce you in great substance.
Oh, well, I was invited late to this panel. I'm just finding out what this is all about. But after listening to the accounts over the last 2 days, especially listening to Javier and Alejandro, I mean, this is what America is becoming right now. This reminds me of Michael Novak's old story of the Polish optimist and the pessimist. The pessimist says, things can't get any worse. And the optimist says, oh, yes, they can. And after listening, this is what's happening in America. I think what I'll do is simply stay and apply for asylum. I should simply stay here. John's story about the court, they couldn't quite figure out what the penalty was. It reminds me of this bit that John Cleese had, where there were two bobbies in the park. And there's a fellow dancing on the grass. And they didn't know what to do because the sign said, no walking on the grass. They couldn't figure out the point. Red Skelton, talk about the culture. Red Skelton had an old joke that's probably from a culture that's fled. He said, they had a military wedding. I think they had a military wedding. Let's put it this way. There were guns there. And it reflected a time when even the people in Dogpatch, USA, didn't think they had a license just to throw that thing away. That's a joke from a culture that has fled. I was listening to John. The Supreme Court in the United States has been the great engine in destroying the culture. They created right to abortion, leading to the killing of about 50 million unborn children. They destroyed marriage. And thanks to Neil Gorsuch, we've established transgenderism, that if Anthony Stevens believes he really is a man, that anyone near him who refuses to respect that judgment is putting himself and his employer in legal peril. And that decision is now radiating outward in the culture, having a profound disfiguring effect on the culture. So to use an old line, to talk about this matter without talking about Justice Gorsuch, as we used to say, it's like playing Hamlet without the first gravedigger. Now, remind me that one of my things I did was I was the architect of the bill that became known as the Born Alive Infants Protection Act. Could we simply protect the child who survives the abortion? because one federal judge told us we couldn't do that. The law wouldn't protect it. So he brought in a bill to protect the child who survives abortion. We're not hiding anything. We're going to be asking you, come back and say, what's different about that same child 5 minutes earlier, 5 months earlier, 5 weeks, five months. It did pass, but we dropped the penalties for the sake of averting a veto from Bill Clinton. But now there's been more killing than we even knew was going on at the time. So we brought back the penalties, and 3 times over the last 9 years, the Democrats have voted cohesively against establishing the penalties for someone who kills a child born alive. My advice to Mr. Trump is to forget about the 15-week bill or the 6-week bill. Let's just talk about that, because the media have never reported on this. They've blocked out the news. We're not talking about all these other things. First, let's challenge you to show us that the right to abortion finds its limit at the point of birth. Let's challenge them to do that. Just listening to the conversations over the last 2 days, it was clear that what people were offering as the rule of law was simply positivism. They say, the rule of law is what accords with a liberal agenda right now. We're telling you what it is. And it's clear to me that the real litmus test challenging all this was a simple test of abortion. Can you tell us who is that human person who's the object the law can protect? And these people can't do that. And I think it's all going to bring us back, as Alejandro and Javier said, it's going to bring us back to truths and natural law. I'll just recall in a couple of minutes just how the American founders did it. That the case for human equality really depended on those inequalities that existed in nature. The argument was that no man is by nature the ruler of other men. In that way, God is by nature the ruler of men, and men are by nature the ruler of dogs and horses. And Jefferson said, anyone who denies that has to assume that the mass of mankind were born with saddles on their backs, and a privileged few born with spurs on, ready to ride them. Lincoln had a story of in the Cooper Union speech about those black slaves who did not throw in with John Brown during the slave uprising. And he said, as ignorant as they were, as illiterate as they were, they could see that the schemes of this crazy white man were not going to conduce to their well-being. That is to say, they may be illiterate, but they are moral agents. They have the capacity to reflect on their own well-being. They did not deserve to be annexed to the purposes of other men without their consent. But so is it, why is that biped what makes him into a bearer of rights? I recall a conversation with one of my students who came to my office one day and said, I've never been as enamored of natural rights as you've been. And as we began talking, the conversation turned to that homeless man in the street who's broken his own life. And I said, why do you regard him as a bearer of rights? And my former student did what we call a postmodernist song and dance. It's the culture, the lens with which we viewed him. And whoa, time out. You're talking about our lens and our culture. You stop talking about him. Tell me, what is there about him that makes him the object, makes him a bearer of rights? Lincoln said that no one made in the graven image was sent into this world to be imbruted, to be counted as a nothing. And so I'd end here simply with a piece I'd written for John years ago on the Holocaust Museum. I went to the Holocaust Museum, and it took a turn that other people have taken, where suddenly there's a vast vat filled with shoes, the shoes of the victims, as the Nazis were trying to take things they could sell again or salvage and use again. And curiously, what came flashing back to me at those moments were those searing lines from Justice McClain in his dissenting opinion in the Dred Scott case on human slavery. And he said, you may think that black man is chattel, but he's a creature made in the impress of his maker. He's amenable to the laws of God and man, and he is destined to an endless existence. That is, he has a soul that will not decompose when his material existence came to an end. And I said, you've got the full sense of the situation here when you realize that the Nazis looked at the same scene and they thought that the shoes were the durables. That the shoes were the durables. I think this conference has brought us back to first things. Thanks so much for inviting me. And I want to thank Miguel, Alexander, and Javier for staying with me through this whole thing. Thank you.
Jonathan.
Thank you. I'm glad that we're getting around to the real stuff. We're headed toward the big guy, right? We're headed. This panel benefited from many things, not only my esteemed co-panelists, but also two titles. You'll notice that Anglosphere and human rights is listed in your panel, and when the rule of law breaks down is listed here. And John did a really good job of combining these two. He must have known the clue before the rest of us did. I'm going to try to tie a few things together that you all have said and get back to the big guy. Now, when the rule of law breaks down, we're quite fortunate because we're left with something, and that is we're left at least with nature, at the very least with nature. And when we're left with nature, we're left with the ability to redescribe nature at different levels. You know, cosmologists might describe it, or certain kinds of physicists on the largest level, in the former, or the smallest level in the latter, in terms of particles. And those are legitimate descriptions of when the rule of law disappears, we might still have physics and cosmology. What we also could describe it in terms of is middle-sized things like you and me. And the common word we use for that is persons. And one redescription of nature, a legitimate one, is in terms of all of the things that you and I do as, for, with, as persons. Now, I tend to like to think of the good in rights and the good in human rights as the best of medieval times, not the restaurant, but that age that gets squished between the ancients and the moderns and gets disparaged a lot. That is the best product of scholasticism, the scholasticism of Oxford, Paris, of Iberia, especially Salamanca, which was then tempered by certain truths of Catholicism that were emphasized in the Reformation in places like Leiden and by people like Grotius, of whom I'm a student and scholar. I won't say much on that now, but I'll be publishing a bit on it in the coming years. Christian liberty was a concept that the scholastics attached themselves very, very strongly to, and Oñate was very strong on this. God left us at liberty to do as we please. Now, we can't do things that are forbidden by God or by nature. We can't do absurd or impossible things, but for the rest, we're left at liberty. This liberty of the Christians was developed as Christians started to go out on the seas and find people that were very, very much unlike themselves, as a redescription of liberty for all of God's children, that is, all persons, as we might describe it. And between the 16th and the 18th century, you had a redescription of this natural law principle through scholasticism in terms of what we would eventually call natural rights. And Jefferson was already invoked, and others as latter-day inheritors of this tradition. Now, up to this day, the truth in and of human rights, and even of the Universal Declaration in its written and received form, involves some of the best of this. And I'll just name 4 of them. And those are a theological truth. We aren't our own makers. We aren't infinitely plastic. Something has been endowed. The preamble in the UDHR doesn't actually mention who the endower is. This is a gift from without, not something that is just found. It is endowed. and there's an endower, and so the big guy is there. Nature, reason and conscience are the two redescriptions of what persons are. That is, all creatures with reason and conscience is knowledge of good and evil in the classic sense of conscience, not my own truth or my own understanding of good and evil, but knowledge of the truths of good and evil. 3, they're personal. That is, they're following on Boethius' definition of us as an individual substance of a rational nature, an individual thing with a rational nature, and Thomas Aquinas' extension of it in the first part of the Summa, question 29, where he says, person implies dignity and person implies relation. You can't have a world in which there's only one person. And in fact, the Trinity exists within that theological system as one God in 3 persons, and that's the model of personhood that he extends. The UDHR continues this personalist approach, which is the metaphysically right way to orient a politics, that is, toward those things that are least deniable, that is, middle-sized substances like you and me, rather than a nation, which is much larger and harder to define. It's real, but harder to define, or something smaller than a human person, which is real as well, but less important politically. And finally, these are jurisprudentially tested. That is, the rights, or at least the person at the heart of the rights, in a Roman and canon law as the creature that they attach to, and in the common law and things like the inheritance of habeas corpus, which attach themselves in a very different way to the same things in the world, using sometimes differently inflected concepts. There are more, but what I want to suggest is that the 3 stages in human rights, we might find ourselves as, in our conversation with liberalism, and asking ourselves what should be retained as we transition towards something else, what should be maintained and retained of these? And I'll suggest, here's the 3 stages. The early stage, 16th to 18th century, is against the state, rights are against the state, or arbitrary collective power, or seemingly arbitrary collective power. They tend to be protections, and that's the way they're articulated, for instance, in the rights of Englishmen, or in the rights given to those Englishmen of the United States who eventually formed their own nation. The second, which is really a 19th century move, is against other persons that might have an asymmetry of power over us, that might affect property, life, limb, reputation, or things of that sort. It gets a little carried away in John Stuart Mill, but he's getting carried away with something that is important. That is, other persons can be as much of a threat to each of us and to our livelihoods and families and religious beliefs as states can be. Now, the third is, I think, happened somewhere between the end of the 19th century and yesterday, and that is human rights are against the entire world, meaning and including and especially nature. And this is really ultimately a Rousseauian rewrite of this. With a friend, I published a chapter called "Did St. Augustine Invent Identity Politics?" The answer is no, but he invented in Christian inwardness that Rousseau metastasized into what we now have as identity politics. In a way, we've become more Rousseauian than ever. And this third one, I think, is what we tend to push against and call it liberalism or hyperliberalism or wokery in its manifestations. But the first two, redescription of nature as a protection of each of us and our communities that we form against arbitrary collective power, and against other persons that might try to take life, limb, property, and reputation, these seem to me eminently agreeable and not necessarily liberal. And so I wanted to put that out there as maybe contentious or contended, but also plausibly true to this group. And I'll stop there.
Jonathan, thank you very much indeed. Now, we actually have 10 minutes left before we have to... Sorry?
No, you got 5.
According to this, you... No. Wait, so I'm going to ask you to answer the one question that, in a way, we all discussed, but left hanging in the air. And so we'll go from, starting with you, Jonathan. All right. The regime of human rights and the whole, in a sense, moving left show, it seems to be facing collapse. That was certainly what you were suggesting, David, that the attempt to fasten it down finally when Labour gets in will bring about a rapid disintegration. That's been said several times. maybe we don't agree with it, but what about each of you telling me how it will happen and how we will benefit from it, so to speak?
I think we won't benefit or have a foot to stand on if we don't have language that isn't inflected or infected with the regime that falls. And so perhaps a return to the status quo ante, those earlier renditions of rights as use, of discussions about the theological origins of them, can help us to have a language that we can stand on in a conceptual framework, which we don't have now. We have many of them competing, but not one that's been articulated well.
I think, well, I can only speak for life in my country in the UK. I think it's plainly evident that things are going to get worse, much, much worse, much worse, and then eventually they will get better, because I don't think that, what else can happen? The question is just how bad does it get? So I think we could find ourselves in 50 years' time in a position where we're looking back on a Javier Milei-type figure who has, I'm not suggesting necessarily his policies, but some leader has managed to turn things around. Or we could be in a genuinely, I don't want to say apocalyptic is too strong, but we could be in a moment of serious, I think, civil disorder, at which point the question becomes a bit more poignant. That's the position that the UK is in. I'm not remotely optimistic about the short to medium term future. I think we face a real period of strife.
Hadley.
Well, I used to say that the left thinks they're human rights to be vindicated all over the globe, but they're not sure they're really humans any longer, right? And I think it's finally, as you say, it's a war on nature. It's a liberation from nature. Till nature finally does kick in. No, I had something else at work. Let me just stop there. I don't know.
Could I just quickly interject on that? Yeah. So at some point, nature will reassert itself, and it's just a question of how painful will that process be. I think that's the way I see it.
My next question, therefore, is we can't. Can you give me an example of when a recovery from something like rock bottom has happened and how it happened? I can think, for example, of the Thatcher period, for example. I can think of the recovery of Germany after the Second World War. Year zero, people were actually eating grass. I mean, they were in terrible conditions. And the leadership of people like Adenauer and Erhard led people out of it within a decade.
Christian democracy. Christian democracy as a broad 20th century experiment was remarkably successful in restoring status quo ante, or even a better version of it for a time. But you needed Christians and religious people generally for it, and that was what was lacking in Europe.
And Christian democracy at the I'm sorry, Hadley.
No, I think so. I was on a program with Steve Hayward and John Yu, and we said, look, here we are, in a place that doesn't recognize same-sex marriage or transgenderism, so on, and protects human life. And I said, how nice it is to be back in America. I liked the 1950s when I went through them. And I think if it could be done here, I can tell you the sources of resolution and recovery are there. So it's account for...
we can't say Millet yet because his experiment is going on for such a short time. But it's such a dramatic experiment that it really does require watching. I see that our time has run out, as predicted by my wife, and I think we must bring this to an end. So I will just briefly do so by saying, first, a word from our sponsor. This is my book. It's available on Amazon, technically published. Sorry, one has to do everything one can here. And technically published on the 10th of June, but in fact available on Amazon now. Sleepwalking into Wokeness, How We Got Here. I want to thank my three co-panelists on this panel. they are obviously people who are good guides, and they themselves are somewhat nervous of what lies ahead. So I think that that's a good reason for us being equally nervous. And I think, on the other hand, I believe in hope, which is to say, it's not just simply being optimistic, which I don't approve of, but hope is optimism grounded in a real determination to try to make things better. Ladies and gentlemen, would you thank the three speakers?
Well, thanks to all of you for that really fabulous final panel. And it's my pleasure to invite to the floor Dr. Ofir Haivry, who's going to offer us some concluding remarks. Among many other affiliations, he's visiting fellow at the Danube Institute.
Thank you very much. So, hello everyone, and well, after a bit of a gloomy panel, let's try to lift our spirits. Hopefully, I think so at least, we achieved some things today and yesterday, and I want to look at them and maybe look forward in case that there won't be an apocalypse in the next year or two, things that we might do. So how did we get here? In January, there was a workshop. A few people here were there. We discussed the rule of law as lawfare and proposed let's have an international conference. And some people said, will we have the money? Will people come? Whatever. And here we are. So we have one achievement at least. So what have we learned? I can speak at least for myself. Hopefully you guys learned also something. But some of my main conclusions are that a few speakers returned to the issue that there is a general corruption of language at the basis of a lot of the problems. So the terms like rule of law, democracy, pluralism, I can bring some others, but you get what I mean, are being distorted to mean all kinds of things, indeed something to mean the opposite of the literal meaning, so that actually the word rule of law is used for things that are patently against rule of law. And this is a first problem that we have to address. I think that apart from, let's say, intellectual or, let's say, political, judicial issues, there is a kind of philosophical battle that we have to fight in order to redefine, maybe a linguistic battle, in order to try to redefine in the public discourse the terms so that they cannot be used indiscriminately. Other terms, like human rights, are not exactly distorted. They're simply becoming open-ended, so they can mean anything. Meaning, if you add all kind of incredible, unheard of rights, then slowly, you know, if everyone gets a prize, so the prize is worth nothing. So basically, my view is that the more human rights are discovered, the actual human rights are becoming weaker, because when you have to spread it, all over, you remain with very little to actually say, this is important, this is less important. Now, we also heard, interestingly, about how rule of law is measured, let's say compliance, how is it even measured? And it appears that there are different measures used by different institutions or groups or scholars, but at least it was established convincingly for me that at least at the EU level, the measuring is extremely opaque, not to say arbitrary. So that there isn't any kind of measure that I could say, I will measure now Hungary, France, Denmark, and I will have a table and I will say this country gets a 7 and this country gets a 5 or whatever. So a problem is even beyond the general dissolution of terms, even of trying to create measures for it. Clearly, it has emerged that the EU administration is using rule of law terminology to impose a centralist agenda on member states that do not comply. And although the EU is a world leader on this, on employing administrative measures against sovereign states in the name of rule of law, it is certainly not alone. We have also heard that the concept of rule of law is used by British, Israeli, and American courts to impose all kinds of ideological agendas that have no basis in the laws or the Constitution. So my own general conclusion is that the very terminology of rule of law has become, to a great degree, disconnected from its origins and is becoming, so to speak, a monster. So I think yesterday, John or someone else mentioned that the European Parliament was once described as a Mickey Mouse Parliament. Maybe some of you do know, but probably most of you do not know, that I think 6 months ago, the copyright on Mickey Mouse was expired. And so naturally, someone pounced on making a Mickey Mouse horror movie. So that the produce is the Mickey Mouse trap. The Mickey Mouse trap. So anyway, it's a horror movie with Mickey Mouse. So what I mean to say is that the European Parliament and the EU institutions have become from a thing that was maybe, the Parliament, to something that is a bit more sinister, or maybe a lot more sinister. And so we should start to think about it in this way. Now, what about the road ahead? So I have seven. I'm coming from Israel, so we use usually biblical numbers. So I have 7 principles or goals that I would like to take from here, looking ahead. Hopefully, some of you people here, some of the people that were with us and left, and some people that couldn't come but are with us in this on this issue will want to join in. I'm offering these as open-ended. We're not. This is not an organizational or administrative type of meeting, but I want you to think about it, and I will be in touch. We will be, all of us, in touch with some of you and try to look at this possible direction. So first, I think that we should look for, I would say, new partners for this project. Basically, it started by conversation by 2 or 3 people. It expanded with a workshop. Now it expanded more with about, I would say, 70 to 100 people that have participated in this conference through the 2 days. Hopefully, I want to expand this to create some kind of larger group that is committed to some extent to this issue. Secondly, not less important, is try to find new institutional partners, meaning not you nice people, but currently this conference, at least, is being hosted by 3 institutions, the European Conservative, the Center for Fundamental Rights, and the Danube Institute. But my view is that for organizational and substantial issues, it would be better that this group grows. I would like it to be 5, 7, 10 organizations and so on. This naturally helps with the financial and organizational burden. But more than that, what I mean is that substantially, I think that the input from more groups would make the whole effort better. The next goal, the next idea would be to have at least an annual rule of law conference. So next year, another one of these. Ideally, I love Budapest, but ideally it would be not every time in the same place. I heard some people here saying, maybe we should have something in America, and I'm all for that, expanding our efforts to new publics. The next step is maybe a bit more complex, but it emerged here that this battle on rule of law a lot of times is being fought inside a country with a sense that it's the Hungarian problem, it's the Spanish problem, but in fact we have seen that it's far wider, and I think that in many cases the way that a lot of the judicial system and the political and even academic system works is that somehow, if some view is also held by people in other countries, it is somehow validated. We know that that's nonsense, because the fact that many people think that socialism is a good idea is nonsense. But we know, on the other hand, that for some reason, a Hungarian or Israeli or American court is sometimes impressed by the fact that people from other countries think that what you are saying is also correct. So we heard, for example, the example of Professor Konterowicz, who was amicus curiae of the Polish at the Polish court when he came and gave his specialist analysis on some issue, and which shocked the Polish left a lot. So I was thinking of creating some kind of committee or something like that of experts on our part that could assist, if needed, writing expert opinions or so on when a case comes up in a specific country. I find out that let's say there's an issue in Spain, so if an expert opinion from someone from the US or Britain appears there, it would help that a lot with relatively a low level of let's say, effort.
1.5 minutes.
Okay, that's great. I would say the next idea is I think we should, again, learn from what we have here going on with the left, creating some kind of permanent observatory. Let's say an observatory on rule of law that could produce reports annual on, and basically produce the reports on our view of what's going on with rule of law, describing or denigrating decisions by the European courts or administration, whatever. It could be an annual report, more general, or a case on specific countries or specific courts. The sixth idea I'm proposing is maybe work toward trying to create our own rule of law vocabulary. Since a lot of the definition and the words are becoming blurry, maybe we should create some kind of our own vocabulary and try to at least present it as a countermeasure to the very vague and weird definitions that we see in many cases. And finally, thinking about going more public, working toward, it can be tomorrow or in 2 years, but working towards having some kind of maybe declaration, maybe a collection of essays from the things that we heard here, maybe a journal, but it depends on how organizationally, let's say, courageous we will be. But basically, my main point is that we want to see this conference, I want to, and I hope that you want to, see this conference as the starting point for something important. At least we will try to stave off the apocalypse. Thank you.